Hafa Adai, and welcome everyone to the Guam Congress Building. The Committee on Health, Land, Justice, and Culture is now called to order. Today's Thursday, April 18th, and the time is about 2:10 p.m. In compliance with the Open Government Law, notice for this public hearing was published in the Guam Daily Post and posted to the Government of Guam Public Notice Portal on Thursday, April 11th and Tuesday, April 16th, 2024. Notices were also sent by email to all senators and all main media broadcasting outlets. And this hearing is being live streamed on the Guam Legislature's YouTube channel. Individuals testifying shall first be recognized by the chair before speaking and begin by stating their name for record-keeping purposes. We'll try to minimize distractions while people are talking and noise, please. And those who are testifying, if you completed your testimony, please do not jump into the conversation unless you are invited by a senator who has the floor. Same thing with senators. Please, we're not here to debate each other or have an argument. We are here to hear their testimony, take it under consideration, and for our deliberations. So if you've asked them a question, please allow them to answer. All right, we have two agenda items today. Bill number 259-37 Core, introduced by myself, Therese and Terlaje. It's an act to amend Section 5118 of Subarticle B, Section 5121A of Subarticle C, and Section 5150 of Subarticle F, all of Article 2, Chapter 5, Division 1, Title 5, Guam Code Annotated, relative to the review and approval of contracts and other procurement actions by the Attorney General. We also have Bill number 235-37 COR, introduced by Senator William A. Parkinson. It's an act to amend Section 45.10C of Chapter 45, Title 8, Guam Code Annotated, relative to affording to the people of Guam and the Superior Court of Guam sufficient time to review and potentially charge a detainee with a crime to adequately protect the community. I'd like to acknowledge my colleagues who are with me today, Senator Jesse Lujan, Senator Tom Fisher, Senator Chris Barnett, Senator Sabina Perez, and Senator Telo Taitui. Thank you, colleagues, for being here today. So we'll begin with the first agenda item, which is Bill number 259-37 COR. So I'm the primary sponsor of this bill. I'll give a very brief opening statement of it. And this bill, well, after the emergency session on March 6, 2024, the Guam Legislature was called into a sixth special session by the Governor on March 8, 2024 to discuss the withdrawal of the Attorney General from the departments and agencies of the Government of Guam. That special session discussed other bills, 237, which is regards to procurement, 254, and Bill number 255. And during this session, senators discussed that these bills should go back to committee and have a public hearing, and subsequently the special session was adjourned. The governor then called us into a seventh special session on March 12 with a measure to discuss, and stated in her letter, quote, that our agencies need solutions now to ensure they continue to receive the legal services they desperately need to continue operating and providing services to our community, unquote. During this session, there were motions made to add the governor's bill into the session agenda, but there were not enough votes, and again, the special session was adjourned. On March 14th, the governor filed a request for declaratory judgment in the Supreme Court of Guam and put out a press release, quote, asking the High Court to decide whether or not the Attorney General may withdraw from representing agencies on the basis that the representation might conflict with the public prosecutor role delegated to him under Guam law, unquote. She also asked the courts if agencies may now hire their own lawyers and whether the Office of the Attorney General, which is funded in part to support these agencies, should be required to pay for the attorneys that agencies will have to hire to do the Attorney General's job. So this declaratory judgment action is continuing in the Supreme Court of Guam. And that's pretty much the background. From March 3rd to March 8th, my office received 15 agency letters urging the legislature to act so that critical procurement, federal grants, and other ongoing CIPS are not stymied. Bill number 259 will allow the agencies to be able to contract attorneys to provide legal services to the agencies until the AG resumes its representation. It allows a procurement council, which is already in Guam statute, to represent the General Services Agency in civil matters if the Attorney General withdraws from representation and with a notice to the AG. It allows agencies to authorize to employ or contract an attorney to provide legal services to the AG until the AG resumes representation, and allows the the agency to also enter into an agreement with another agency that provides legal services. And it allows the agencies to conduct solicitation or procurement that is estimated to be $500,000 or more without the assistance of the Attorney General upon notice to the Attorney General. So in other words, the goal of the bill was to allow procurement to continue despite the current statute that says that for contracts of $500,000 and more, the AG must review or must be participating in that procurement all the way through, advising the agency, and in the end, the Attorney General must also sign those contracts. So we have received communication from the Attorney General that he is continuing his role in signing those contracts, reviewing and signing those contracts in the end. He will continue. We also received a separate letter by the Attorney General indicating that he will continue to review and advise agencies if they sign that they are not being represented by him, that he is reviewing those and participating on behalf of the government of Guam. He has also indicated to us that if agencies were to procure, as proposed in this bill, an attorney to provide legal services to that agency until the AG resumes representation, those contracts would be signed by the Attorney General. There was a fiscal note on the bill by BBMR. It says the Bureau notes that DOA historically employs a procurement council within GSA and is budgeted within its annual budget act appropriation. As such, the Bureau does not anticipate any fiscal impact to DOA with the proposed role of GSA Procurement Council. However, the Bureau notes that a majority of line departments, agencies that engage in solicitations, procurements above $500,000 do not currently employ or contract legal representation at this time. Therefore, funding to employ or contract such services would need to be identified within their authorized budgets. Furthermore, BBMR noted that it is unable to identify a financial impact to departments and agencies due to the following circumstances. The proposed legislation being dependent on the formal withdrawal of legal representation by the AG. Number two, the rate or cost of legal representation being dependent on employing a full-time attorney or contracting out the services on a case-by-case basis. And number three, the unknown time frame when formal withdrawal and formal resumption of representation by the AG occurs. All right, so we'll now receive testimony on the bill. Director Byrne, you're invited. And anyone else who has signed up to testify, you're welcome to have a seat at the table to testify on this bill. Director Byrne, you may proceed.
Thank you, Madam Speaker. Madam Speaker, Senators, my name is Edward Byrne, Director of Administration. With me here is the Deputy Director of Administration, Lisa Fisher. Department of Administration and its staff thanks the Speaker for introducing this bill. It will help to resolve the logjam caused by the Attorney General's decision to withdraw representation from Department of Administration and its division, General Service Agency. On March the 6th, I wrote to you, Madam Speaker, detailing the expected effects on the work of the department as a result of the AG's withdrawal. The situation has not really improved, although the Attorney General's office has requested the files for review of 2 procurements under protest. Please don't put it too close, please. Thank you. This request occurred on Tuesday. DOA would join with other agencies and departments in confirming the adverse effect on the operations of government as a result of the AG's decision. An already lengthy and complex process has been rendered harder through the uncertainty now prevailing. I cannot but help note that government vendors are also anxious regarding uncertain outcomes and unpredictable delays in the procurement process. Vendor anxiety results in higher prices. Addressing the particular functions of DOA, which is the substance of this bill, DOA is on the critical path to completion of almost every process for the line agencies of the Government of Guam. We provide professional procurement, human resources, and accounting services for these agencies. Within these services are transactions which may require legal input. We cannot plan for when legal issues may arise. They arise out of transactions, and access to legal advice may be critical to completion of the process. It has always puzzled me why certain agencies have permitted attorney employees or outside attorney contracts, but DOA has not. Since DOA is at the heart of the government, it, above all, should have the easier access to such representation. We have been well served by the Attorney General's office under this and previous AGs, but sometimes, no doubt due to their workload, we have to compete for their time. Inevitably, this will delay process finalization. DOA certainly appreciates this bill and its intent to resolve the current situation. I would respectfully note that employing an attorney to provide legal services is difficult when the contemplated resumption of an Attorney General representation may occur. Agreements with other agencies may also be difficult, for they themselves are also dealing with the effects of the AG's decision. Contracting with an attorney also has its challenges, as that may not secure full-time support. DOA would request that the legislature considers granting DOA permanent authority to employ a staff attorney on account of its critical position. With HR, for example, dealing with the Civil Service Commission, and the AG had previously withdrawn employer representation from there. In accounting, navigating the local and federal statutes and regulations which govern our transactions, and supporting the Authorized Procurement Council, already dealing with the many issues which procurement entails. For the present, DOA thanks senators for considering this bill. It will help DOA move tasks forward while the controversy moves through the judicial system. The Deputy Director and I would welcome any questions. We request that you advance this bill. Thank you.
Thank you, Director Byrne. Thank you, Deputy Director. Is there anyone else who would like to submit testimony on this bill? If not, then I'm going to invite my colleagues to question for the Director. Senator Lujan, no? Senator Fisher? And I'd like to welcome Senator Joanne Brown. Thank you, Senator.
Yes, thank you very much, Madam Speaker. You're good, okay. All right, thank you, Madam Speaker. I'd also like to thank you for bringing this bill forward. The territory has been suffering for some weeks now under the uncertainty of the Attorney General's position. Agencies are suffering, of course, and our Speaker saw a problem and is bringing forward a measure to fix the problem, and so thank you very much for that. Mr. Byrne, I've litigated against agencies in procurement matters, and I've litigated on the behalf of agencies in procurement matters. I feel I have at least a working comfort with procurement law. It sounds ridiculous, but I have some affection for the procurement law. I like the way that it moves slowly, and I like the way that it moves granularly, because we don't want to rush around spending money, right? So I like that. And you said something that I hope it didn't go under the radar, and I'd like you to expand upon it if you could. What you said about vendor uncertainty can lead or does lead to higher prices for the people of Guam. Could you explain what you meant by that?
Yes, Senator, thank you. As you perhaps know, much of my career has been in the private sector, and therefore I'm fairly familiar with pricing practices. If you have or perceive to have a risk, and the risk is that somehow that when you propose a bid to the government, and the possibility that either that bid will be unduly delayed or indeed never comes to fruition, and you've managed to secure whatever goods and services you need from your subcontractors or sub-vendors in order to fulfill that contract, then vendors are going to price that risk into whatever proposals they make. And competitive practices might rule that out, but if everybody evaluates that risk the same way, then I think all the bidders are going to try and price that risk in a similar fashion.
Okay. I like the fact that you're using the word risk, and any agency worth its salt or any private business worth its salt will always contemplate risk, and I would assume build that into their offer or their price. Is that roughly correct?
Yes, sir.
So if a potential bidder feels that, well, let me back up a little bit. Can it be, sometimes it can be extraordinarily expensive for a offeror, a proposed bidder, a potential bidder, to prepare the bid. Is that correct?
Yes. I mean, certainly, I spent 15 years in the construction industry, and the bids there are very substantial, and it may take months to prepare that bid. Mm-hmm. Of course, not all our procurements are that complex, but certainly there are some that do fall into that range.
And I know that Guam enters into some very complicated, from time to time, complicated procurement processes, and we are probably on the cusp of beginning a very, very expensive capital improvement project that will be entailed, that will be receiving bids, et cetera, and so forth. Is it possible that uncertainty may affect the price of bids we receive to, build a hospital or whatever we're doing?
It's certainly possible. I can't speak for vendors or those who might potentially bid, and it would be actually improper of me to put myself too much in their position. Okay. But I certainly am concerned about uncertainty. I've often made reference to the very long supply chain that we have here on Guam, and vendors have to make very particular arrangements to make sure that the goods, and indeed the services sometimes, arrive on the island when they're supposed to. And sometimes they don't, but certainly most vendors, from what I can see, at least attempt to do so.
Okay, I guess that was, I'm kind of beating around the bush here. It's a long way to get to, I think is a valid point, which is certainty in the environment of procurement leads to efficiencies which save taxpayer money.
Yes, it would be nice to be absolutely certain,
Yeah.
but even a shadow of uncertainty is unsettling.
Okay, and just one final question, sir. I'm uncomfortable, and I'd like to hear your observation. I'm uncomfortable with the concept of the Attorney General's office, or any attorney, dancing in and out of litigation. That leads to uncertainty and injustice to the taxpayer and injustice to the agency. I very much appreciate what the speaker has done here. She's trying to staunch a wound here. But I hope that in the future, if that arises as a problem, we can address, this phenomenon where the agent, I'm here today, I'm gone tomorrow, and back the next day. So anyway, that's just my editorial comment. Thank you very much, and thank you, Speaker.
Thank you, sir.
Thank you, Senator Fisher. Senator Barnett. Senator Teitzigui.
Thank you, Madam Chair, and good afternoon to my colleagues. Good afternoon, Director Burns. Good to see you. It's been some time.
Thank you, Senator.
Mr. Burns, there's been speculation on what's really going on, because some people say that the Attorney General is not doing its job, and then there's some, but he's coming back saying that he just needs something in writing to move forward on any kind of representation or giving advice, and he also provides a written document that allows you to sign off that he does not, is not held liable. A lot of people are confused about this and how it's going, and we're getting some agencies coming up to us saying that they can't do anything, but yet there is an alternative. This legislation in front of us is actually just makes it clear. I think it just makes it very clear that you would be able to seek legal advice, outside of the Attorney General's office, but with the emphasis of that he formally withdraws. And that's what's confusing for me, is that formally withdraws versus having you signed a waiver of his liability between the two. So can you kind of explain, give us a circumstance, a situation, for instance, a recent one, that where you're having difficulty and that this legislation would actually help assist you instead of going through the proper procurement process through the Attorney General's office so that he looks at all the documentation?
Senator, I will try.
Okay.
But the confusion that you referred to is in my mind also. So I'm not sure I can really explain to you, I guess, the Attorney General's position, because I don't fully understand it. But my best understanding, and I heard the speaker refer to certain communications that the Attorney General has made with her office, but that certainly was unknown to me. So I personally have received no clarifying information. We did receive 2 letters from we and the other affected agencies did receive 2 letters from the Attorney General, and a third letter which you referred to as a kind of, I can only describe it as a promise to offer some representation, not terribly well defined, if the agency director signed a kind of waiver as to how the Attorney General should use information garnered during his representation for other purposes, including what I believe he called civil and criminal investigations. So, you know, it's, to my mind, that was a conditional offer, because I've never yet, in my whole experience, had an attorney say to me, well, we'll represent you, but you have to sign something that I would have to get my own legal interpretation of. So that's the uncertainty, that's the confusion, and I have to say it's still confusion in my mind.
So, Mr. Burns, since you are confused, you know, and trying to understand how this works, have you attempted to meet with the Attorney General to sit down and try to clear up your concern or your confusion?
No, not personally. I believe some other agencies may have done.
Well, I think it might be a good idea to do that, especially you are in the same building as the Attorney General, that you can just go upstairs and talk.
I need to run after him
them.
because he's due to move, right?
But, so Mr. Byrne, it also says here that unless formally withdraws, you know, in this legislation, do you see any issue with this if you feel you're not moving forward with any kind of answer or review of any procurement that the Attorney General has taken himself out of?
As I indicated in my testimony, there are some procurements which are incomplete. I mentioned that...
Do we have a copy of your testimony, Mr. Byrne?
I'm afraid it's handwritten, but I will provide.
Okay, that makes it very difficult for us to kind of review what you said unless we rewind the tape in some circumstances. So I appreciate...
Yes,
yeah.
I will, and that's why I'm taking time to repeat it. But there were two protest letters which on Tuesday, you know, these protest letters were received some time ago, and he was aware that we'd received them some time ago. He requested the files on Tuesday. So I can't, because it's so recent and I don't have a result, I can't tell you what he will do and whether there will be a result or no result. The procurements that you submitted to the Attorney General for his advice, how many have has been delayed longer than normal? Or has he addressed, the Attorney General has addressed everything that you brought to him so far? I mean, and we have to remember too, that even though you submit a document, sometimes the documents are not complete, and it has to go back. But I'm hearing from some agencies that, oh, we sent it to the Attorney General 2 months ago, but they failed to tell us that there were documents missing that the Attorney General needs to continue his review of the paper. So these are completed documents that have been submitted, procurement, to the Attorney General. Are there any of them you know, in delay longer than, let's say, 3 weeks? Other than the two
that you mentioned.
Protests that I just referred to,
Okay.
I think we're still waiting to hear from the Attorney General about some, I think there's two, where there was a request to review an RFP, and that seems to be stuck there. But thank you for asking that question, because it does give me the opportunity to talk about one of our most important procurements, which is the procurement of the third-party administrator for the upcoming health insurance plan for fiscal 25. In prior years, we have had the benefit of having a representative from the Attorney General's office throughout that negotiation. I can't, we're about to start that because we have to do that in order to complete the process by the beginning of October. And I really, again, it's another area of confusion. I don't know how we're going to handle that.
Well, he's right upstairs. You know, I'm sure you'll be able to have a meeting with him, and it can be at your convenience, I'm sure. But let's clear up any of that confusion that you have.
I would certainly try, but
comments that are being made, you know, without being, you know, leaving certain information out to make it sound like, you know, he's gaslighting, which some people believe he is. But then again, you know, when you lose an election, you know, I'm sure you get all upset about it and start calling the, you know, the Attorney General names. But in the meantime, I think, Mr. Burns, you've always had a good rapport with individuals, and it's just a matter of just giving him a call and talk to him and
yes,
finding
Senator,
out what's going on.
I was certainly, you know, and I've been trying to choose my words carefully not to put anybody in a position, but I would point out that the agencies didn't create this situation. The Attorney General initiated this whole process. So other than listening to his testimony at the Committee of the Whole, when you were talking to him, I don't know that, you know, he has made the step towards the agencies either. But, and you know, if talking to him involves signing a piece of paper, and you know, that obviously would be a deterrent.
Yeah, but I'm pretty sure that, you know, your questions are simple enough that he can answer, so you won't be so confused. So thank you, Madam Chair, for the opportunity. Thank you, Mr. Burns. Good to see you, as always.
Thank you, Senator.
Thank you very much, Senator Teitzigli. Senator Perez, any questions or comments?
Thank you, Madam Speaker. Yeah, I remember in the special session, this bill was actually entertained, and that was the language. The formally withdrawals was actually provided by the Attorney General during the Committee of the Whole. I think it was more of a matter of procedure, more protocol. I felt the recommendation was based on protocol, just so that there's a formal process in place. So that was the reason behind that language there. So, you know, definitely this bill should have been, you know, I felt it should have been addressed during that special session. Unfortunately, we're here today, many weeks later, maybe a month later, in fact. So it's unfortunate that time has gone by. In looking at Section 2 of the bill, so the word governmental body comes up. You know, what is your understanding of that? And does this Section 2 cover all agencies of the government?
That would be how I would interpret it. Yes, Senator.
Okay, so in the definition in the procurement law, it actually leaves out some agencies, so it's not all-encompassing.
Now, of course, some agencies do have their own attorneys. You know, for instance, DRT already has, I think it's 3 attorneys.
Okay, and do you feel the need to incorporate those other ones that are not included in this definition?
Well, if whatever the Attorney General is doing precludes them, yes, they should be included.
Okay, all right. Yeah, and again, you know, I feel this bill is an important bill, a stopgap measure. And in regards, the other question I have is the verbiage in the bill that says that the agencies are authorized to hire an attorney until the Attorney General resumes representation. So how does that play practically? You know, so are we, if you do an RFP for an attorney, are you hiring them on a monthly basis, or how does that work? How would that work?
As I mentioned in my testimony, I think that's a little awkward. We haven't worked through how to deal with a temporarily employed attorney, or indeed a temporarily engaged contractual attorney, you know, because both of those those engagements would hinge upon a decision of the Attorney General to resume his activities. So either you're left with the possibility of saying, well, the whole thing is contingent, a contingent contract, but that in itself has a difficulty. Contingent contracts, have their own difficulty because that's subject to its own interpretation.
Okay. So if you're thinking about the best value for the government, what would you recommend as far as language is concerned?
Well, as I testified, my own recommendation, as far as DOA is concerned, is actually to employ a full-time attorney, and that would resolve that. For other agencies, I think I would defer to their particular directors, but I think you would have to derive a contract that said you could terminate those services at any time upon the operation of that agency director.
Okay. Thank you. Thank you, Madam Speaker.
Thank you, Senator Paris.
Thank you, Madam
Senator
Chair.
Barnett.
More of just a comment, really, but at least my latest understanding is that the Attorney General supports the measure, and Director Byrne does too. But I wanted to comment more on this narrative about the delay of contracts and procurements that's being caused by the Attorney General. It's just interesting to me that we see these pronouncements, but when you actually go and do the homework and you talk to the AG or you talk to the agencies, a lot of these issues they're blaming the Attorney General for delaying are really things that are still stuck at the agency. So I think it's incumbent upon us to kind of weave through what is actually fact and what is fiction that suits this narrative. And I've actually heard that the new financial management system is causing way more delays than the Attorney General ever could. So just my comment, ma'am. Thank you.
Thank you, Senator. Senator Brown, any questions or comments?
Not so much any questions. I mean, I've heard the testimony that's been provided, Madam Chair. I think, the challenge the Attorney General has, obviously, is this issue's been put on his lap because, the question has been raised, how can he prosecute and represent department and agencies at the same time? So I can't say that this is anything that he generated himself. I see him here. Maybe if you could allow him the opportunity to testify, then I can further, maybe I might have some questions for him, Madam Chair. Thank you.
Thank you, Senator Brown. All right, Director Byrne, Tijusmasi, for your testimony. I do look forward to that in writing, and otherwise we will transcribe it. But thank you. Do you have to leave? Or are you going to stay for a while? Okay,
I will stay as long as I can.
All
Thank you.
right, thank you. Okay, so we're going to hear, Attorney General, you're going to testify on this bill?
Yes.
All right,
Thank you.
you're welcome.
Thank you, Madam Speaker. On Bill 259-37, this bill was a response to what had occurred because the governor had filed a declaratory judgment action with the Supreme Court of Guam, and essentially what was going on with the public auditor, the AG's office, in dealing with investigations that were prompted, many of them by the public auditor, as well as 2 government corruption cases that had evidentiary hearings that were going on, and the defense attorneys were arguing that the Attorney General had a conflict of interest because the AG's office had sued a client, which was the public official. That's how they were trying to characterize the relationship. We had temporarily withdrawn, and I emphasize and underline the word temporary. And again, the governor had filed her request for declaratory judgment before the Supreme Court of Guam. At this point, senators, although Madam Speaker had been involved with assisting in the drafting of this, which seemed to allow the AG's office the ability and the latitude to declare a withdrawal, I'm asking that the senators, because the Supreme Court has expedited the declaratory judgment decision, we were essentially waiting for the judiciary to make it clear versus our lawyers getting sanctioned for violating the ethical rules, whatever they may be in this particular situation that I just mentioned. The Supreme Court will be coming out with a decision within, one might say, a few weeks, if not very quickly, because they granted the briefing schedule an expedited briefing schedule. The governor has already filed her brief as of Monday. Ours is due as next Friday. There's an amicus that's coming in, and then the reply brief, and then the oral argument in May. So I would respectfully ask, because there's so many issues that are involved here, including the Organic Act requirement that only the Attorney General can represent the government of Guam, and these issues are going to be discussed and debated in the legal briefs and the case that's going to be before the Supreme Court of Guam, that action on Bill 259-37 be delayed or deferred because of all these legal issues should be answered very quickly. Initially, before the declaratory judgment, we were in a situation that we would have to wait for the decision of Judge Tolentino and Judge Terlaje on these two criminal cases in order to decide if the AG's office was properly investigating and prosecuting government corruption cases, and then could also be simultaneously providing legal services to essentially that department, but obviously the people that we were prosecuting were the management heads of the department, which is a bit unprecedented in Guam's recent history, that situation didn't occur. So all these questions, again, we're going to the appellate court of essentially what will be the decisions of Judge Tolentino and Judge Terlaje. That is the essence of what's going on right now. We said that the Supreme Court didn't have the jurisdiction because we wanted the lower court decision and then appeal it to the appellate court, but the Supreme Court decided they're going to hear the essence of these questions that Bill 259-37 essentially addresses. And it's the reason why these services may or not be provided as being characterized by the governor. It was a temporary withdrawal, and the guidance that we were seeking is now going to be given to us one way or the other in May. Also, I would note that I heard a comment from a director of administration. That is not true. My office is very efficient, not only in processing the contracts out of our office, but also whenever a government official, whether it's a senator and even the private organizations that call our office and ask for some consideration on expediting a contract, we are expediting them. I think the most recent example was the GPA CCU request and the legislative mandate that we process out that temporary contract quickly within 5 days. We got it out literally probably within 2 days of it going back and forth. So given the events that have occurred since the introduction of Bill 259-37, might the senators and the committee consider not taking any action? It might be the prudent thing to do depending upon how the Supreme Court rules. Thank you.
Thank you. Is there anyone else to testify?
No,
All right,
thank
then
you.
I have a couple questions. First of all, I want to go over the timeline one more time. First, the two criminal cases, right?
Correct.
We have no decisions in either of those. One of those has been under advisement over 100 days. We were hoping, while we were being called into a special session, that that was going to be issued so that we would have some basis to move forward. That did not happen. Before the declaratory judgment action was filed in the Supreme Court, on February 28th, 22 agencies were sent a letter by the AG's office informing them that because of ongoing investigations based on OPA audits, ongoing investigations by the AG's office based on OPA audits, there was a potential conflict, and the AG was temporarily not representing them in civil matters, including procurement. On February 29, the AG clarified that he would continue to review and sign the contracts as the law requires, contracts over $500,000 to be signed by the AG, that you would be doing that on behalf of the government of Guam, reviewing whether they were legality, as to legality and whether they followed the procurement law.
Correct.
All right, and then on March 18th, you sent a letter, AG sent a letter to all the 22 agencies again. So this affects 22 agencies, that's what we're talking about. The AG will provide legal services to that department despite anything, but will provide legal services to that department if the agency agrees that the AG represents the government of Guam and not the individual, not yourselves individually or in any form a personal capacity, right?
That is correct,
And
Madam
so that letter was sent to those 22 agency heads again. On the back of it, it says, acknowledge and agree to above, and then it's the director's signature.
That's correct.
So this was for them to get your review, for example, going through the $500,000 contract before they get to the contract, to review RFPs and do all of that on behalf of the government of Guam, in your opinion?
In actuality, and you are correct in the timeline, after, and this was the committee of the whole, we had indicated that, Madam Speaker, that we have been signing off on contracts after the review, going back and forth with the department on the errors or corrections that were needed, and above our signature is the statement that making clear that we're approving it on behalf of the government of Guam, essentially. So as the check and balance requires, that is how it's being signed. So the idea of procurements not going through is not the case.
Right. Contracts being reviewed, if they're final contracts, they need the AG's signature.
And procurements.
That is, there's no kink in that system. They're
Correct.
being sent to your office and you review them and you decide whatever based on your representation of the government of Guam. When the agencies, for example, need a review of an RFP, so they're not at the contract stage, they're in the beginning. They want to know whether this RFP is for a contract over $500,000 is sufficient. They want to know that ahead of the game, not in the end. So they need legal advice, right?
Right.
Ultimately, since you're the one going to review the contracts in the end, the statute
Correct.
suggested that you should review those in the beginning, the RFPs, so that they're consistent, throughout. And we don't have to keep redoing these procurements. So these services, are they being provided reviews of RFPs for the 22 agencies?
For that March 18th letter, that was not only intended to address that issue, but basically general legal services that they may need. To my knowledge, I believe it was only the Guam Visitors Bureau that had signed off on it.
Okay.
So that's why I'm saying that they have an option to provide the legal
Right.
services.
So that's the option for the 22 agencies.
Correct.
The other agencies that outside the 22,
We
they
provide
should
it.
be all going through your office for their RFPs and everything.
That's
Is
correct.
DOA one of the 22 agencies?
They are one of the 22. They're under the Bank of Guam investigation.
Okay.
No banking services
All right.
contract.
And, all right. So, of course, the bill is intended to just give a practical, move forward solution as opposed to, I don't think it impedes any decisions being made by any of the courts. They have to continue to make their decisions, but I guess it's this, we have a scheduling. The oral arguments, as you said, are not until May. We have been called in several times by the governor as this is an urgent issue. I think if there are agencies that are currently without counsel, that the prospect of waiting until the middle of May for the courts to decide some Organic Act issues that might not even solve what we're going to do moving forward either way, I feel like we should have a solution in place before May. We should, for the ones that we need to decide, because if they say, on the Organic Act issues, that's going to be for your office to determine what you're going to do moving forward, perhaps. But for us, it's the legislature that wrote these laws that say that AG is going to review the contract or the RFPs, the AG is going to be consulted during this part. So I see no reason why we should not affect those if we can, and as soon as possible, if they're holding things up.
One of the things that's, I guess, the Supreme Court has before it is they're dealing on the governor's interpretation of the facts. Our office is actively reviewing whether we're going to withdraw all those letters right now, given the way that we're, because we could have gone without the letters out of an abundance of caution. We issued it, but literally, you know, we're the ones that created the cautionary action. We could, and we're considering that as we speak, withdrawing those letters, kind of showing the Supreme Court that this is, the facts are only regarding, like you had pointed out, they're before the two criminal cases that are trying to decide it. Tomorrow they could come up with a decision. Today they could come up with a decision. We were just waiting for somebody in the judiciary to come up with a decision on these unique set of facts that are presenting to us. If the legislature passes this law, it's further going to change the fact pattern as the governor has presented it to the Supreme Court. This will have to be disclosed to the justices, that the facts as they presented it and the 4 questions that has already been starting the briefing and the governor finished her briefing are now changed because this law will have passed, arguably. But bigger than that is whatever the Supreme Court decides in its decision could make this law moot or not consistent with the Supreme Court of Guam's decision. That's why I'm going, things are so volatile, and I have full respect for what you're saying, Senator, that the legislature was called into session by the governor, and the governor filed her paperwork with the judiciary. This is an active play right now with the judiciary. So this is not productive for purposes of what's going on. We're indicating already in our briefs that upon the Supreme Court of Guam's decision, we're going to be taking action on what the AG's office is going to go forward with. Because there was a part of this, we wanted the judiciary's direction, and that is what's happening as we speak. The judiciary is about to give some direction. They say they have jurisdiction, and they're going to make a decision. And it's probably going to be rather quick because they granted the emergency briefing schedule that the governor asked for. So I just think practically, not to not pass this bill as it's written, but to hold off and to. The constitutional nature of this bill is, and the Supreme Court noted it already in one of their orders, can the AG even pull out of representing without any statute in place? And can that be done when you have an organic act, a constitutional statement that the AG shall be the chief legal officer of the government of Guam? An example that we're using, there's a law in Guam law that says that the AG only represents the executive branch agencies and does not represent the legislature and does not represent the judiciary. That's unconstitutional because the Organic Act specifically says the Attorney General is the attorney for the government of Guam. The Organic Act defines the government of Guam as the executive, the judicial, and the legislative. So that law that was passed by a legislature in the past, and it wasn't around, I believe, when I was first the Attorney General, but it's unconstitutional because the Organic Act, the higher law, says that the AG shall be the officer for those 3 branches of government. The government of Guam is made up of 3 branches of government. That's just one example of the complications that are being created by the legislature passing certain statutes. But
Complications by the legislature passing certain statutes.
potentially,
Potentially.
that's all I'm saying.
Or in the past. So these statutes are on the books. They are before the Supreme Court. The Organic Act questions, of course, we are not in any way impeding with the Supreme Court's authority to review those questions. But I cannot understand why anyone would suggest to this legislature that if the Supreme Court is going to look at questions like if agencies may hire their own lawyers, that's strictly a matter of Guam law, whether we say they can or they cannot. They say whether the Office of the Attorney General, which is funded in part to support these agencies, should be required to pay funding of the Attorney General's office, strictly a legislative function. And if we're going to wait until the end of May or if we wait longer for the decision to come out after the oral argument, we will not have a solution for these agencies. And so I do not see that as the solution. I see they will interpret the law as it stands today. The Organic Act, yes, that's very important. But these other laws as to who's going to pay for what, if we, at the end of May, have a decision either way on that, I feel like it's going to require legislative action, and we are able to act today. Why would we not act today and just move those things forward and make it very clear so that I don't know. I want these agencies to be able to act with some clarity as well. I want you to be able to act with clarity, and I want them to be able to act with clarity. And where we can do that by law, that does not impede on the Organic Act or your authorities under the Organic Act or the Supreme Court's authority under the Organic Act, I feel it's my position that's why I want to move forward.
Yes, Madam
All right.
Speaker, thank you.
Thank you. Senator Lujan. Senator Fisher?
Yes, thank you very much, Speaker. I think a lot of, the Speaker and I don't agree on a lot, but we're on the same page with this one, and I think that it would behoove all of us to listen to that particular commentary that the Speaker just offered. A fact I know during the Rapadas administration, during the Limtiaco administration, during, I don't know, who am I leaving? There was the Camacho administration. Basically, these were the prior elected attorney, well, Mr. Moylan too, prior elected attorney generals. And one of the things I noticed is that we didn't have this problem in those prior administrations, and we didn't have this problem prior to the present Attorney General sending out rash and not particularly well thought out letters informing the agencies that they were essentially going to be on their own. And then I don't know what to make of this. Frankly, after you, sir, Mr. Moylan, created this chaos, now you've told us that you may just say, never mind, and we're going to withdraw the letters and let the Attorney General or let the Supreme Court know, and perhaps that will withdraw our particular irons from the fire. Again, it's a problem. It's chaos. We have to fix it. I'm not going to, no, we're not going to take responsibility. This lays on the Attorney General, this mess, this chaos. Thank you, ma'am. You've heard me say it before, but thank you for trying to fix it. Thank you.
Thank you, Senator Fisher. Senator Taitukwi.
Thank you, Madam Chair. I did have a line of questioning prior and asked Mr. Byrne, but he has already left, to speak with you, Attorney General Moylan, because he seems to be confused about some things, and I know he's in the same building as you, so I asked him I know that you're very open, allowing people to come and see you at a short notice, to address his concerns and his confusion about what's going on. I did ask him the question about what RFPs or contracts are being delayed and how long, and really didn't seem he had any answers to that. So I know that you're doing what you can at the Attorney General's office. However, I do have a little reservations with regards to, the waiting for this determination from the court, and I don't want to delay anything, and if you can ensure this body, as well as the public, that you are not delaying any of these contracts or RFPs that need to get out. We have funding that is going to expire at the end of the year, and you know how important that is to get it out. So
Yes.
Greatly appreciate you continuing to work on that. Go ahead, comment.
Senator Taitukwi, thank you for your question and your raising this issue. Never in Guam's history that I'm aware of has there been about 22 audit reports coming from the elected Office of the Public Auditor, bringing into scrutiny 22 departments or agencies under the governor's responsibility, whether it's through a cabinet appointment or through a board that was appointed by the governor. And this is in partial response to Senator Fisher's allegation that something is afoot with this Attorney General. This did not come from the Office of the Attorney General. This came from the Public Auditor in terms of the GMH, you name it, on the 22 departments. as part of the executive branch, it is our responsibility to investigate and to prosecute. Never before in Guam's history has there been that many government officials at the cabinet level point of investigation and never in Guam's history has there been a government official claiming that they can't be prosecuted or to disqualify the Attorney General because a grand jury has decided to indict that government official. When I was the elected Attorney General the first time, we had a government corruption division, but the defense attorneys never raised this type of issue. Now I came back, there was not a government corruption division created. We created the government corruption division. From all indications, the former AG was not giving any credence to Public Auditor B.J. Cruz's reports that he was issuing. And when you look at the letters that we have with the attachments, you'll see those reports were going back into the former Attorney General's purview, his time period, most of them. So this is not a situation where it was created by the AG's office. It's a situation trying to adapt to ongoing criminal and civil investigations of a department's top management officials that has caused the situation, and the defense bar, which came out with these arguments that, in fact, the AG's office can't sue a person that they say we represent. And we have, from day one, said we don't represent any government official. And in fact, you senators, since 1975, had made it clear through 3109, 3108, and 3104, the AG is supposed to investigate and prosecute corrupt government officials specifically, and they call it public officials. We're supposed to vet whether or not to represent a government official and to decide whether or not we're going to prosecute them or represent them. And then in, again, 3109, it just talks about the civil and the duality of the civil and criminal responsibility of the duties of the AG. And we allude to the Federal Department of Justice. They have the same type of purview as the Attorney General. But these questions are novel. It's questions of first impression, the Supreme Court likes to call that. These are not questions that have been answered in the Camacho versus Barrett-Anderson case in 2017. They were not answered in the 2005 line of decisions that came out of my administration. And it's just something that needs to be answered. It's going to be answered, it appears. And I'm not in disagreement with the Bill 259-37, but I don't think that it should be passed at this time because everything is coming very quickly. And the Supreme Court is unprecedented how quickly they're coming to answer these type of questions. So from an AG's office perspective, we're just respectfully suggesting that this not be passed so quickly. It will change the fact pattern before the Supreme Court.
Thank you, Attorney General. And you're absolutely right. I read everything that comes out of the OPA's office since the 35th Guam legislature. And look at all these discrepancies. In fact, I filed when leaving Camacho was the Attorney General, a complaint on an OPA report regarding the Port Authority of Guam. And nothing was done. Absolutely nothing was done. And our public auditor continues to bring this to the forefront, but these last Attorney Generals have been turning a blind eye. So I thank you for finally addressing all these discrepancies. It's not just that we go after directors, but the employees too. I mean, I think someone here is even going after an employee who's mismanaging funding, and prosecuting them. But when it comes to a director, that's stirring up a lot of dust, and that's exactly what you're doing. And I greatly appreciate it. We're not very popular, for doing it.
Thank you, Senator.
But I could tell you one thing, the majority of people on this island appreciate what you're doing. Finally bringing to forefront, those who lost the people's trust. And the worst part is they think they can get away with it. And many of them say just because they're in a position that they can get away with it. So I greatly appreciate the work that you're doing at the Attorney and your staff as well. Because it's not easy. Especially when you're going up against someone who's been in a position that's high up there. People too afraid to go after it. It just, it boggles me. I mean, the whole Pacific Star scenario, what happened there? Did the Attorney General look into that? No. What about the Chamorro Land Trust signature from a director who signed something that was not supposed to be signed illegally?
Right.
Did anybody go after that? No. I can tell you who that was, but... So, regardless what people may say, you're definitely trying to bring back that trust and prosecute those who have been wronged, who are wronging the people. I mean, doggone it, we pay our taxes to pay for people who are breaking the law? That's kind of...
Yeah.
It's ridiculous. So, but I think, more discussion needs to be made. I trust the speaker she's done everything she can to try and resolve this issue that we're having right now. And I'm looking forward to just, more discussion on this, and hopefully we can come to a resolution. And pulling back those letters, if that's what it needs to be, then let's do it, if you need to pull those back. And we'll have to address the concern, though, like you said, my concern too is you have, or the governor has provided those questions to the court. This will change it. The questions will change. So what do? Wait for another hearing? Or another declaratory judgment she's requesting for? Which some people think that declaratory judgment doesn't, it's not important. It is. We have a law that allows declaratory judgment on Guam. There's no question about that, right? But most jurisdictions don't have that. The process of law of appeal, is given to other jurisdictions, but this is unique to Guam. And it was once repealed, allowing for Guam to have a declaratory judgment.
Yes.
And then it brought it back onto the books now. So there's a lot of variables here, a lot of pieces to move. But I think we can do that, resolve this, and move forward. Because right now, I'm happy to know that most of these concerns from DOE, all the procurement and the documents that are being brought to you, you're addressing it right away.
We are.
And that's the most important thing. So you are addressing it.
Yes.
Okay. Thank you, Madam Chair.
Thank you, Senator Taitzigui. Senator Barnett.
Thank you, Madam Chair. Matt AG, right before you walked in, I said, I think he supports the bill. But thank you for lodging your concerns on it. And yeah, I have to concur with Senator Taitzigui. I mean, I had always said in the previous AG's term, it was almost like we had an appointed AG again, because it seemed like all he could do was review contracts for procurement. I think for me, moving forward in this, it's really a question of where's the delay and who's it really being caused by? Because, I mean, while I understand the importance of a lot of these projects, I mean, I've got projects in my agencies that are awaiting review or at the agencies themselves. So for me, it's really hard to figure out what is at your office being reviewed and what is really stuck at the agencies, and what is the administration just trying to heap the blame onto you and your office. Like, I mean, we had the biggest laugh when they tried to blame the delay of the construction of the new Simon Sanchez High School on the Office of the Attorney General. And I mean, this administration has been in office for 6 years and haven't so much as turned a shovel, but very eager to blame your office. And just for clarity's sake, can you tell us anything about the status of the Sanchez rebuild procurement and where it is? Is it at your office, and what's the situation?
And thank you for that, Senator. And we do have a website that we did put on our website, the actual tracking, if you have a specific contract that was transmitted to the AG's office, and it shows it being sent back or it currently under review. And it's usually within 30 days that we kick everything out normally. If there's an expedited, we do that. For the Simon Sanchez, it's with DPW. And every time it comes back to our office, Fred Nishihira deals with it, as well as another attorney in our office, Tom Keeler. Those two, and I've spoken with them in the past week, 2 weeks, I know that you've made inquiry with our office, being very concerned about the progress of this. So it is with DPW. Whatever support that they need for purposes of processing out the Simon Sanchez, we're providing. And ultimately, when it goes through our office, it has that stamp. It will be signed one way or the other if it's ready for signature, and it has the stamp on it that we're doing our job on behalf of the government of Guam. So.
Thank you for that, AG. I had previously brought up in my comments when Director Byrne was testifying delays being caused by the financial management system. My office has been in receipt of, I mean, really an avalanche of concerns from, you know, vendors.
The AG's office today, we are not getting our reimbursements, our procurement moving because of that computer system, from what I was told this morning.
Okay, and so I had sent a FOIA to the Director of Administration because a lot of staff, I mean, from the agencies and from the Department of Administration have reached out to my office, and they're telling me there's issues with voluntary and involuntary payroll deductions occurring after March 1st. They're telling me that there are issues with the vendor of this FMS and the government of Guam having to pay additional fees for upgrades or other things that I feel for the price tag of $31 million should have been included in the initial package. So I'm just hearing a lot of these things, and like I said, I sent a FOIA, I requested all correspondence between DOA and the vendor to really just, because they don't provide anything willingly. I mean, we're senators and we have to send a FOIA request, for crying out loud. And they've already extended, they actually extended 10 days on the day after I sent the request. So it looks like we're going to be waiting on this information that should really be given willingly to the public and the senators. But I have to ask, has your office been in receipt of any concerns with this financial management system?
Well, we're the ones that rely upon it as well. I was told this morning that several of the modules are not working properly. So it's called, you know, computerization. The DOA staff is relying upon that computer to work. It's not working from what I was told. First, the problem, the delays, I think last month, was transitioning into the new system, and now the new system isn't working from what our office was told today. There's modules in it that aren't functioning properly.
Okay. Yeah, and another question I had is I was reading in the media the governor's filed a brief in this case that we're talking about, and basically she's requesting that you not be allowed to investigate or prosecute any agencies, which to me is just insane. I mean, normally the standard response would be, oh, we're confident the investigation is going to play out and we're confident that, you know, no wrongdoing will be found on our part. And instead what we see, and I'm very glad that you really took us back to the genesis of some of the defense counsels who have raised these concerns. And I mean, even in this body, we have practicing defense counsel who I think has a vested interest in the weakening of the Attorney General's office. And I'll just say that for the record, I totally agree with that statement. So if that ruling comes out in the favor of the governor, what then would happen to these investigations that your office is conducting?
That's the troubling part of what's going on right now. The governor has pulled in a Organic Act officer to have another Organic Act part of the government. We're all in the Organic Act. So the speed in which this is moving, the issues that are being raised, the history of all that has brought us to this point in Guam's history, from an appointed Attorney General made by the legislature to now an elected AG made by Congress and the legislature, and then questioning that duality that exists in at least 3 states and 4 territories and the Department of Justice. We all follow the same model. The AG has the ability to investigate and prosecute government officials. The AG also sits with those same government officials and provides the legal guidance. Once the Supreme Court of Guam acknowledges that that is the model that the people of Guam have adopted, we're clear to go. We continue with our prosecutions, plus the 2 cases that are pending with Judge Terlaje and Judge Tolentino, game over. That's what the governor has done. She's jumped the normal process. And that's why I see the silver lining in this. We're not going to wait a year to 2 years to get a decision. It's coming up very quickly. And then what we do after that, we'll have to figure it out. But I mean, a decision is coming from all indications, and it's a high probability they're going to issue that decision very quickly.
Yeah, I mean, I get the silver lining maybe that the decision is coming quickly, but I think the gray clouds looming on the horizon is using recent history and the relationships between the judiciary and the office of the governor. I think that I'm a little worried about what the decision is going to be, not so much about how quick it's going to come out. But again, echoing Senator Taidegui's comments, I just say keep moving forward. We sat through a previous AG's term where, you're right, the public auditor did the work. I mean, he basically said, here, take it to court. You know what I
Yes.
mean? Especially with the audit,
Investigate it,
the
take it to
scathing
court.
audit, smoking gun audit relative to the procurement of the quarantine facilities, I think is something that you definitely should move forward on if you haven't already.
And Senator, what we also are concerned about is that a government official through the governor has a conflict of interest, arguably herself. And this is with due respect that I say that, because one of the largest investigations going on right now is the Bank of Guam banking services. Why did that contract end? And the people of Guam were not allowed the opportunity to have it bid out again or RFP'd out. So, and the person that's part of that family is the person that's before the Supreme Court of Guam saying that the AG should not be having this ability, this duality to
People see
investigate.
it. People see it, AG. I think a lot of the movements that are happening, it's very telling, the motive behind it. So again, keep moving forward, and I pray for the best with this court decision, that it preserves the people's right through the office of the elected Attorney General to investigate instances of corruption and to prosecute them to our fullest ability. So thank you again, Attorney General. And
Thank you, Senator
Madam Chair.
Senator Barnett. Senator Brown.
Thank you very much, Madam Speaker. And, you know, I'm going to have to join the chorus on this side of the table, Mr. Attorney General. You know, of course, the desire is to have the blame totally on your shoulders. And, you know, your enemies out there, and there's some here, have no desire to see you succeed. And there's a lot of reason. There's a lot of money. There's a lot of power and abuse of that power that's involved that don't want you investigating these cases. And they have, and I'm sure will continue to throw anything and everything they can against you to discredit you in the eye of the public. I think we've seen too much abuse, and it permeates in every corner of this government. And it's been allowed to do that for many, 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 many years. Holding government officials, and that includes everyone who's been paid for by the taxpayer of Guam, accountable for their actions has not been the standard. And you're right. I mean, our elected public auditor, who, while some of us politically don't always agree or did not agree with him when he was in elective office, at least in terms of his current duties of fulfilling his duties as public auditor, has repeatedly come forth with these issues of misuse and abuse in this government. And you're right, other than putting it on paper and other than him being interviewed publicly about it, nothing happened. And that's probably the reason why some of us, including myself, are here right now, or coming back after all these years, is because we are very dissatisfied with the direction that this government has gone in, especially when we see abuse in the highest corners of government. And they come after us, as they're coming after you. They use their black ops that are paid for with public funds to discredit you, as they have continually attempted to discredit those of us that are on this side of the table that don't play ball. Because at the end of the day, this is our community, this is our family that lives here. We want to ensure the safety and well-being of our people. And when we see a continued abuse, it's just not acceptable to us. And you're up against the tide. You're up against a major tide that is, especially when leadership allows this kind of nonsense to occur. Especially sometimes they themselves have their hands in the cookie jar. So I understand you didn't put yourself in this situation, even though there's those that want to blame you for it and say you're the reason that this chaos exists. You've been put in a very disadvantageous position because you're expected at one end, you have your duties to represent and ensure that these procurements are proper and legal. And at the same time, you're also, your responsibility also includes ensuring that public officials and the actions taken by this government are responsible. And if they're not, then it's your duty to ensure that these issues are brought forth and prosecuted as so. So I have no questions. I think you've relayed your position, you've relayed your concerns, but do understand there are those of us in the government that want to see these issues addressed. We want to see this government cleaned up. We want to see public officials in fear that if they do something wrong, that they will be held accountable. That has not been the standard. And we're not happy to see the abuse. I know our people out there see it, especially when it takes away from the benefits that they're supposed to receive from this government, when the money that they put forth is not there to take care of the critical needs that they expect in this community, when the money's not there for the law enforcement, when the money's not there to ensure proper health care, when the money's not there to address proper education, and the list goes on. Because there are others that have, without reservation, without conscience, continue to take money from the people. They have no reservation. As a matter of fact, they think they're entitled to it. They think there's an expectation that when you win an election, then by all means, that comes with it. You get to have the contracts, and you get to have the favors, and you get to do the hiring, whether it's needed or not in this government, because you got people to take care of who've supposedly been taking care of you. That's the expectation. That, to me, should not be an acceptable standard. So I appreciate your opportunity in coming here and providing your testimony. We certainly will take that into consideration, but I think the intent to try to portray this as if it's the Attorney General that's created this chaos. Your detractors are there for their own ulterior motives. But the rest of us, we want to see a responsible and accountable government that's free of corruption. So thank you very much, Mr. Attorney General. Thank you, Madam Speaker, for the opportunity to comment on this bill.
Thank you, Senator Brown.
Thank you, Senator Brown. Senator Lujan.
Thank you, Madam Chair. Good afternoon, General Moylan. Good afternoon, staff.
Good afternoon, Senator.
General Moylan, can you just reiterate again, one more time, what the ramification of the passage of this bill may have on whatever decision the Supreme Court may come up with?
When the governor submitted her request for declaratory judgment under 7 GCA 4104, her attorneys set forth all the exhibits of what the facts were as they saw it. This bill, 25937, did not exist in those fact patterns. The Supreme Court then proceeded to find jurisdiction to hear the case, and they set a briefing schedule. The governor has now submitted her brief with an excerpt of record, which is additional documents to support her position on these questions. Our brief is due next Friday, and then there's an amicus that's relying upon all these facts as they exist. And as the Supreme Court gets ready for the oral argument and looking at the briefs, they're going to make a decision. The problem with adding additional facts in it is that it's not going to be part of the record, or the Supreme Court's going to have to change their analysis if they do see this as part of the analysis, as opposed to being patient, waiting for a decision that is very quick in our eyes as attorneys to come out from the judiciary, and then respond accordingly after the decision comes out. So it seems to be one of the options, and in my view, a more prudent option, to just have the public hearing as is being done today on this bill 259-37, and then await the Supreme Court's decision, which is going to be quickly. In terms of anything that's going on out there, and I apologize I came in late, I didn't hear all of Director Burns' testimony. I can guarantee you 100%, and I get briefings on it every week, if not every other day, that my the Civil Division at the AG's office is receiving, reviewing, and processing all contracts and procurements that are coming through our office. We're also providing certain advice on like the project, the Simon Sanchez project, in conjunction with Department of Education and its lawyers. They've got 2 lawyers at the Department of Education on the Simon Sanchez project, as well as talking with the board itself on that particular project. That's the question about, is somebody helping them, DPW and DOE, contract manage the construction. It's being done actively, and I mentioned Deputy Nishihira as well as Tom Keeler they're assigned to, and I spoke with them within the past 2 weeks specifically about it. So that's where we are, Senator. I don't see, and if there's a particular project that is of concern, I should be aware of. Somebody should contact me. I know with the Chamorro Land Trust Commission, we've had discussions with my attorney, Lee Miller, that's in communication with the chairperson at the Chamorro Land Trust Commission on a lease or contract situation that's facing them, and in light of the documents we've sent over to them, to just confirm that you understand we're not your attorneys, government officials, and we can proceed forward with it. And they seem to be very conducive to understanding that, which is Guam law. But that's what the Supreme Court now has to deal with, is it Guam law? And that's what Judge Tolentino and Judge Terlaje are being asked to answer by the defense attorneys in those criminal prosecution cases, the government corruption prosecution for the Department of Public Health sanitary permit and the Guam Regional Transit Authority for having hired a person that wasn't qualified for it. Those are the 2 government corruption cases that caused this question to be raised. So
basically you're saying that should this bill pass then, prior to a decision coming out from the Supreme Court, that the decision that we come up with, because this was not included in the governor's submission, is that it could have changed the outcome of their decision?
When the Supreme Court starts to take a matter under advisement, they're going to look at what's before them. If this comes in after all the briefing has been done and the excerpts of record and documents have been submitted, it could change the equation. That's all that I'm worried about. But you have 3 decisions that are coming down within any day now. 2 of them would be the Superior Court decisions. The evidentiary hearings have been conducted. The matters have been submitted to the judges. Those were the ones that started our February 28th letter that came out. So, yes.
Okay. Thank you, Madam Chair.
Thank you, Senator Lujan. And I'm grateful my colleagues brought up some of the points that were raised in the governor's brief. They are arguing, for example, that the AG may not withdraw from his Organic Act duty to serve as the attorney for and legal advisor to executive branch agencies on the basis that such representation conflicts with his duty to investigate or prosecute as a statutory public prosecutor. Mm-hmm. Yeah, and I also agree with my colleagues who, I'm in full support of the AG having the discretion to prosecute, even agency heads, that the AG should have that discretion, especially after audits or investigations. Some of those audits I requested. But we have seen that discretion used in the opposite way by some of the AGs. And for example, they have defended the directors in their actions, and which maybe, okay, I mean, I don't know. If it's a case-by-case basis, I would think, but I think, I don't know. I acknowledge that there is discretion. There's discretion whether to prosecute. There's discretion, whether to defend a director or not. There's discretion, but I want to take a look at, if we can. I don't want to create a situation where we are authorizing agencies to hire lawyers to fight with the AG. What I want is really to limit it to procurements, because the legislature, not even too long ago, a bit in the last decade maybe, was the one who put the AG in the middle of the procurement process for all the agencies, and it was the legislature who said, you sign the contracts, review them, because we had so many procurement issues, yes, and we wanted these to be, outstanding. We wanted to make sure that they reviewed not just as to form, but as to their legality and their consistency with the procurement law. So that was all written in there by statute, by previous legislatures. They put the AG in this process. I like the AG in that process. I want to continue that. As a public policy person, that's what I would be in favor of. The previous legislatures also put the AG in the process of procurement to advise the agencies as they went along, so that we wouldn't have in the end, a contract and the AG comes in and says, no good, you didn't follow the law. For these big contracts, these are critical, we wanted the AG to advise them all along, right? And this is how you should be doing your procurement. This system has worked out since it's been implemented. Of course, agencies sometimes say it causes a delay, and different AGs, I think, have been implementing it different ways, right? Like how hands-on they are with the agencies and their review, going through it, or even their interpretation of what they can do sometimes. But if we could look at the bill. Mm-hmm. So sections 1, there are 3, substantive sections. Sections 1 and 3 are strictly talking about the procurement. And so they say, section 1 says, this is the government shall use procurement counsel to assist GSA in its procurement. And so my amendment is to add the words, it says, provided that the Office of the Attorney General shall represent the GSA, this is existing law. I'm adding in, unless the Office of the AG formally withdraws from such representation, then the Procurement Council shall represent GSA in such civil matters upon notice to the AG. And this is Procurement Council representing the agency or the GSA in procurement, up to the point of signing a contract and up to the point of, that's it. And then on number 3, section 3, it's the duties of the AG again. I'm only adding in a sentence that says, notwithstanding the foregoing, if the Office of the AG formally withdraws from representing any agency, instrumentality, or public corporation as provided in this section, while the agency is conducting any solicitation or procurement which is estimated to result in an award of $500,000, then the agency may conduct the solicitation without the assistance of the AG upon notice, blah, blah, blah. That's 2 exemptions for procurement. And temporarily, as you said. But section 2, I can see, this was a much more general authorization that if, right now, agencies are not allowed to hire lawyers, not all of them, unless the legislature authorizes that specifically for that agency. And we haven't done that. We wanted the Attorney General to represent these agencies. But I was going to make an exception, again, temporarily, where if the AG withdraws, then the agency shall be authorized to employ. But I do not want that to allow the agencies to hire, for example, a lawyer to represent its director while the AG is prosecuting its director, or allow them to hire just another lawyer to fight with the AG's interpretation of how we should move forward with the procurement. That's not my intention at all. I just want to, I guess create a substitute, for the AG where the discretion of the AG has led them to not be able to
Madam Speaker, where this has gone in terms of the analysis is, as we're preparing to submit our brief on this, is that it's like the governor. Can the governor herself say that, I feel I have a conflict and I don't want to be involved in this? What happens if that is stated, I don't want to do this work? The governor obviously characterizes if I don't want to do this. I do want to do this, but I want to make sure that I'm not violating an ethical rule that lawyers are under. The way that the bill is kind of worded right now, it raises that question. Does the AG have the ability to step away in any manner if the Organic Act says that only that person is the chief legal officer? It's kind of like this is time sensitive, and it's only going to last as long as this question remains unresolved by the judiciary. Is there an ethical violation for a lawyer to be doing this? Once either the judges or the Supreme Court makes its decision, this is no longer an issue. If this comes into play, it raises the question, because the Organic Act says that there's only one person that shall be the chief legal officer of the government of Guam, this is kind of saying that, well, not really. And that's why I kind of use the example of that statute that talks about AG not being the attorney for 2 branches of the government. It's kind of like, even if I was to say, I don't want to represent on this thing, then replace the AG. That would kind of like be the Organic Act, because the Organic Act doesn't say that there can be a substitute to the person. I know the 2005 airport decision kind of says you have as much power as the legislature wants to give you. But you take that to the logical conclusion, and that's why I use that example of that statute that says the AG is not the representative of the judiciary. Well, that's a complete anomaly to the Organic Act. It says the government of Guam. It doesn't say only a part of the government of Guam. So that's the type of stuff I didn't really want to have to deal with as we move forward to this important question before the Supreme Court. Because can the legislature, the old rule was, and under the airport decision in 2005, the agencies were not considered part of the government of Guam. That's how the Supreme Court of Guam kind of looked at it. It never went to say that a department of the government of Guam could be taken away from the Attorney General. That's what has happened in the past 17 years on certain situations, like Department of Education. That's a core part of the government of Guam. It's a department of the government of Guam. How can they have an attorney that's outside the purview of the Attorney General, not an Assistant Attorney General? That's why it gets into the Organic Act question. The Organic Act says clearly, if you've got the government of Guam entity or department, the AG is the chief legal officer. So it's raising Organic Act questions in this bill that I don't think need to be answered immediately at this point. And given a few weeks that we're talking about here before the Supreme Court, I'm just kind of, and I'll make it, Madam Speaker, I did agree with, and you showed this to me, and at the time of the Committee of the Whole and so forth, I do believe that this was I guess a proper bill to the extent that if we control the situation and withdraw, then that's okay. But in fact, if we look at the Organic Act, I don't think that is okay. It's like a governor or the public auditor who's also an Organic Act department official saying that I don't want to be the public auditor on these type of things. Or the governor saying, I don't want to be the governor on these type of things. I don't think that we have the choice. And by the way, I'm going to the Supreme Court, saying to the Supreme Court, I agree 100% with the governor. I am supposed to provide legal services to this department, and I am supposed to bring before a grand jury evidence that we think might be indictable on a government official. So I'm kind of, it's like we're going together saying that I can't do this, just so I don't get sanctioned by suing a client, that sort of thing. That's the context and the background on this. So I do agree with what you're saying, Madam Speaker. I just don't, I'm worried about how if this passes the way it is, it could even tie up our argument as the Supreme Court asks us the questions at oral argument. The question of, in the Washington, D.C. history, when they prosecuted Bill Clinton, they prosecuted him under a statute that allowed for the appointment of a special prosecutor. The special prosecutor law had a sunset provision in it, that after a certain amount of time, there shall be no more special prosecutor, which was Ken Starr at the time. Without that authority, only the Attorney General could prosecute crimes. So this is the situation we're dealing with before the Supreme Court of Guam. How do you reconcile the AG shall be the chief legal officer of the government of Guam and then be saying, but for GSA, it's okay for him to give it to somebody else? That's the type of legal analysis that I'm kind of worried about. Because the Supreme Court arguably could say, nobody can replace the elected Attorney General under our current Organic Act provision. So that's the situation that I kind of see here, Madam Speaker.
As any of the directors who you sent the letters to, the 22 directors, where you said, I can represent or advise your agencies if you acknowledge that I am representing the government of Guam and not you personally?
Yes.
Have any of them called to discuss that with you?
Former Governor Therese for the Guam Visitors Bureau signed off on it and sent it back. So there's now 21.
All right, because I've been receiving questions about the Chamorro Land Trust Director. He did not sign that, I guess,
right.
And now the commission is waiting for legal advice.
Yes.
Because the director did not want to sign that with your office, but...
The Assistant AG, Lee Miller, I spoke with him, I believe, last week. He's going to be talking with the chairperson of the Chamorro Land Trust Commission to have the commission consider signing off on that March 18th letter. So that's where that particular question is at.
Is there any requirement that you see that the AG represents the directors themselves?
Yes, that's in that situation in 3108 of Title V. It talks about if a government official is sued, the AG has the ability to look at the facts and circumstances and choose whether or not representing them would be consistent with representing the people of Guam's interest. That's the type of situation.
Right, yeah, and that's existed for a while,
Yes.
and it's actually been used. We've seen
Yes.
AGs go on either side of the issue, right?
Correct.
But I guess that's why I'm wondering, why do we need to tell them again that
Right.
the Attorney General doesn't necessarily represent them personally versus,
100% agree with you. That is why Judge Tolentino and Judge Judge Tolentino and Judge Terlaje-AN's decisions have been eagerly awaited, because they're trying to disqualify me from government corruption cases, saying that you can't do that, that my client is that government director. It's not the clerk. They're targeting the government directors. That's why this is unique and unprecedented in Guam's history. They come up with a novel argument trying to use the current professional rules of responsibility, saying that we represent one and the same. The department is the director is the department. Therefore, you're violating the ethical rules by suing them before a grand jury.
yes, so that's what they're trying to say in the brief.
Right.
It looks to me like they're trying to say that according to the Organic Act, you cannot prosecute a director.
Yes.
If you have advised that director.
Correct. It's totally anomalous, and that's why I use the Department of Justice. This happens every day in the Department of
Right.
Justice. It's well recognized. So, but Guam hasn't addressed it on our jurisdiction. Just like the airport case kind of took a slant on their interpretation of the Organic Act. But I mean, this is the environment we operate under as lawyers. We're barred by this jurisdiction, so we have to make sure that we're ethically.
Have you been asked to review any the FMIS contracts or any protests to that, or any issues that is causing what's the delay in this new financial management system? We've been receiving so many complaints from agencies that
Yeah,
this is being held up, that's being held up. It's not the contracts that are being held up, it's the payment on the contracts that are now being held up. It seems they are not able to address those things. Is that your understanding?
That is my understanding. It's the technical side of actually getting that system to work. The computer system is broken right now. It's not working.
But there's no legal matters pending before you regarding that?
No,
All right,
not that I'm aware of.
okay, thank you.
Thank you, Madam Speaker.
Any other questions? All right, if not, Situs Masi, we will, there being no one else to testify on this bill, we'll call this hearing on this Bill 259 duly heard. It is 3:50. Situs Masi. Thank you.
Thank you.
All right, we're going to move forward. The second agenda item is Bill number 235-37. This is Senator Parkinson's bill. Oh, Senator Parkinson. All right, I want to thank again my colleagues who are here. Senator Lujan. Thank you. Senator Barnett, Senator Perez, Senator Brown, Senator Taitekwi, and Senator Parkinson. All right, so we will ask the sponsor to introduce the bill, 235. Senator Parkinson.
Thank you, Madam Speaker. Bill number 235, COR, amends the current laws that mandates that a probable cause hearing happen within 48 hours, extending this period to 72 hours. This bill comes at the request of Attorney General Douglas Moylan, and as we navigate through this hearing, I want to express that though at times we may disagree or I may ask hard questions of the AG, I fundamentally respect the Attorney General and his office and their enduring commitment to safeguarding our community from criminal activities, which is a goal we all share. The impetus for this bill stems from a recent incident where constraints within the existing 48-hour window necessitated the premature release of a detainee under Attorney General Moylan's watch. This proposal therefore seeks to provide the AG with a broader time frame to ensure that due processes are meticulously followed without compromising public safety. It is imperative to recognize that the landscape of legal precedents, such as the U.S. Supreme Court's decision in Riverside versus McLaughlin, currently sets a national standard at no more than 48 hours. However, it is also noteworthy that exceptions exist within states like Alabama and Louisiana, where under specific conditions, this period can extend up to 72 hours. Today's hearing will critically examine the constitutionality of the proposed 72-hour rule, and I am particularly keen to hear robust legal arguments from all sides on this matter. Furthermore, the urgency of this proposal prompts us to question both the timing and the operational challenges that have led us here. It is crucial to understand why such an extension is deemed necessary now, and why now more than ever, people fear the fast-growing crime rate since 2022, when this AG took over. We continue to be unsafe in our streets and in our homes, and that is why I've introduced this and other measures, like the Castle Doctrine Bill, which aligns with the pressing need to empower our citizens in defending themselves amid rising criminal activity. I trust that the Chair will expeditiously address the need for Castle Doctrine reform as well, which has been in your committee for over a year. As we proceed with today's hearing, I invite my colleagues, legal experts, and the community to engage in a transparent evaluation of this proposal. Your insights are invaluable as we seek to balance the scales of justice with the practical needs of law enforcement and the fundamental rights of the individuals. At this time, I'd also like to read in the testimony of the Judiciary of Guam, and so forth goes. Dear Madam Chair, thank you for the opportunity to provide testimony on Bill number 235-37 COR, an act to amend 45.10C of Chapter 45, Title 8, Guam Code Annotated, relative to affording to the people of Guam and the Superior Court of Guam sufficient time to review and potentially charge the detainee with a crime to adequately protect the community. The judiciary recognizes the measure's intent to provide the Superior Court sufficient time to review. However, we wish to clarify that the court faces no issues holding magistrate hearings within the 48-hour time frame. This deadline has been consistently met by the court for the past 16 years since its establishment by the legislature in 2008, when the statute was first expanded from 24 hours. Thus, the proposed measure primarily supports the Office of the Attorney General in ensuring their timely filing of criminal charges. As we have previously noted, no judicial officer wishes to risk unintended release due to the delays by the OAG. To prevent such issues, the judiciary proactively established a process to accommodate the OAG with morning magistrate hearings. The process for these hearings were agreed upon and memorialized following a meeting led by Presiding Judge Alberto C. Lamarena III on February 9th. The OAG, the Public Defender's Office, the Guam Police Department, and the Department of Corrections were present at the meeting along with our magistrates and judiciary staff. A copy of the agreement was then circulated to all attendees, as well as the Office of the Speaker, attached herein. Under the agreement, morning magistrate hearings are to be held exclusively for complaints that would not otherwise meet the 48-hour requirement under Guam law if heard at the regular scheduled 3 p.m. magistrate hearings. To request a morning hearing, the OAG must provide written notice to the Superior Court by filing a complaint no later than 4 p.m. the day before, with exceptions made for urgent cases involving violent crimes. Upon receiving the complaint, the clerk's office distributes copies to all pertinent parties, ensuring everyone is informed and prepared. The judiciary also requires that declaration of probable cause include a record of the time of arrest to maintain transparency and adherence to the law. On average, magistrate judges preside over 115 magistrate hearings per month. Since the court implemented this process, the OAG has requested 4 morning hearings, and the matters were heard by our magistrates. Finally, while the judiciary acknowledges that the proposed measure is a policy decision for the Guam legislature, we respectfully raise previous testimony from the branch regarding potential constitutional violations with expanding the timeline to 72 hours. Though we will not belabor these concerns here, we have attached our previous testimony and the relevant Supreme Court opinion for the committee's review. We also respectfully note that although the bill states that other jurisdictions do not require that 48 hours to be absolute deadline, only 3 jurisdictions have a 72-hour deadline in their statute. And these are under specific conditions. For example, Georgia permits a 72-hour period only if there is an arrest with a warrant. Otherwise, the period reverts to 48 hours, in line with the Supreme Court's mandate. In closing, magistrate hearings are a collaborative effort involving multiple government agencies. Addressing these challenges effectively require more than a statutory change. It requires ongoing commitment and cooperation from both the prosecution and defense, as well as from the Guam Police Department and the Department of Corrections. Thank you for your consideration of this testimony. Daniel T. Rosette, Administrator of the Courts. And with that, Madam Chair, I yield the rest of my time. Thank you.
Thank you, Senator. If I could just clarify, do you wish this hearing to proceed on this bill? Are you still looking to this bill to be passed?
Yes, ma'am.
All right. Okay, I'm going to remind everyone to please limit their testimonies, questions, comments to the matters that are at hand, not other bills that are not before us during this hearing. And those who are testifying, please wait until you're recognized by the chair. Please answer the questions that are directed to you as briefly as you can. And for those who are asking questions on the senator's side, please allow them to answer their questions. All right, so we've got several people signed up for testimony. We did receive a fiscal note. The fiscal note says the Bureau, BBMR, has sought input from the on the financial impact of the proposed bill from Judiciary of Guam, has not received any official comments as of the date of this fiscal note. The Bureau notes that there will be a potential impact to DOC relative to detainees being held longer, such as costs for manpower, security, meals, and other associated costs and services while detained up to 72 hours. All right. So we have signed up Peter Santos, Stephen Hattori, John Morrison, and Douglas Marlin to testify. Are there others? All right. So if we could hear from Peter Santos.
Thank you, Madam Speaker. Buenas dan half a day para hamzuni manorabli naman senadora dan senador. Guini gahalo mi mismo naguma era igimay taltaw guahan. Guao si Pete Santos, abogado defensor, ginini alternate public defender. I am here to testify against this bill to expand the time standard for magistrate hearings to determine probable cause from 48 hours to 72 hours.
Madam Speaker, sorry to interrupt. I just want to know, who do you represent? Are you representing the public defender, or are you here in a personal capacity?
I am here as a representative of the alternate public defender.
Okay, so your testimony is based on that. Thank you.
Yes. We are stakeholders in this particular issue. I represent...
Please proceed.
Yeah, I represent indigent defendants who are appointed and paid for by the government. Please allow me to put things into perspective, lest we allow the Attorney General to gaslight the public, and least of all, this honorable body of legislators. As we heard from the judiciary, they have no problem, yet the bill as submitted, put their name in there, and they felt the urge to respond and clarify. So that's what I mean by gaslighting. In reality, most jurisdictions require a hearing within 24 hours after an arrest, but the U.S. Supreme Court has ruled that 48 hours is close enough for constitutional purposes. But even if the hearing occurs within the required period, a constitutional violation still may arise if law enforcement delayed the hearing for improper reason, such as looking for evidence to support probable cause. Failing to meet the deadline likely will justify the suspect's release unless law enforcement can show that there is an extraordinary reason warranting the exception. Now, honorable senators, the reality on Guam is we're just going to 48 hours by default. And can you imagine if you are held for 48 hours in a dirty, filthy, crowded prison without being afforded your right to go see a magistrate judge because of bureaucracy. We're not doing it on Guam because of ongoing police investigation. We're doing it because people can't get their act together and get the reports done on time, as the Supreme Court, as the judiciary has more delicately put it, okay? And now imagine we want to go to 72 hours. Imagine if it's you or one of your loved ones or your constituents that have to sit there for 72 hours in this location by default without even having to show that there's a need to hold you for 72 hours, just because people can't get their act together. The AG must believe we're in North Korea or Cuba or something. This bill, 235-37, submitted by Douglas Moylan, is ill-informed, unconstitutional, and inorganic. Similar to the misguided bill that was proffered asking this legislature to invade the province of the judiciary and pass laws that govern the admission and practice of attorneys on Guam. This bill will not pass muster. This bill has a severability clause in it that says if any part of the bill is invalid, it shall not affect the rest of the bill. However, the bill changes one word in the statute, one word, 48 to 72. It's one word because it's hyphenated. So this hearing is really an exercise in futility because that will not pass muster. And that's the only thing that's changed. It's an exercise in futility, just like 95% of the things that this Attorney General does. This bill will be dead on arrival if passed. So let me address and correct the AG's mistaken and dishonest assertions in order to enlighten this honorable body with the truth and reality of how the magistrate process works. Now, I speak as someone who has arrested people as a police officer, written reports, and I've been a prosecutor who has charged people with crimes and have gotten convictions. And now I'm a defense attorney who represents people being charged and brought before the magistrate. I myself have even been a magistrate for the purpose of determining probable cause in pretrial confinement and release when I was in the military as a JAG officer. So I know what I'm talking about. The real root of the problem here, ladies and gentlemen, is that the Attorney General's office is not able to meet its burden and legal duties because he doesn't know what he's looking at. He has no real experience to fully comprehend and appreciate the problems, and it's really quite easy to fix these issues with several of the suggestions I will go into later. But first, let me give you the correct and honest version of what happens when a crime is committed and reported, or it occurs in the presence of a police officer, and then an investigation ensues, and reports are eventually written. If during the course or at the end of the investigation, an arrest or multiple arrests are made, the arrested person or persons may be booked and released or booked and confined. When an arrested person is booked and confined, it triggers 8 GCA 845-10C, the 48-hour time standard. It is worth noting that Section 45A says, an officer making an arrest under a warrant or any person making an arrest without a warrant shall take the arrested person without unnecessary delay before a judge of the Superior Court. It is fortunate that no one has sued the government of Guam for routinely employing unnecessary delay. When a police officer arrests a person, they fill out what's called a GPD Form 7, or arrest record. The person is then booked and confined in a Gatnya. The process can take as little as an hour, in my past experience to as much as 6 hours after the arrest has been effectuated, for them to be delivered into the custody of DOC. Officers complete their reports ASAP if it is a book and confine. It is reviewed by a supervisor, then the following morning it is submitted to GPD Records and ID section for processing. GPD is supposed to have the reports transmitted in the morning to the AG's office, at least when I was there, no later than 9 a.m. The prosecution division takes the reports, reviews them to make charging decisions, and draft magistrate complaints to include declarations. This needs to be done by noon for submission to the courts, who then in turn have no problem preparing for their hearings that occur at 3, if it's submitted by noon. So that's the crux of the matter. the submission of the complaints and the declarations are not timely submitted, it busts the 48 hours, and then the defendant is released. In reality, though, GPD reports more often than not, get transmitted late. They're late, more like 11 to as late as 1 p.m. A seasoned and experienced prosecutor can receive the preliminary reports and draft a declaration in about 5 to 10 minutes. The problem is that the Attorney General has chased away the majority of the seasoned prosecutors and has instead opted to hire rental attorneys to do the magistrates. The attorneys with no experience who take much, much more longer to draft a declaration, and those declarations nowadays often goes to the magistrate and they experience a high rate of rejection.
Mr.
No
Chairman,
probable cause
may I
found.
object? The characterization and the decorum to this body includes to the Office of the Attorney General and my licensed attorneys in that office. The declarant is maligning people that have come to Guam in order to provide their services as attorneys and are licensed by our Supreme Court of Guam. May I respectfully request that the declarant be reminded of the decorum required before this student body. Thank you.
Thank you. Thank you, Mr. Attorney General. Mr. Santos, you may proceed. Please
Thank you.
be aware of
Madam Speaker,
your
thank you.
audience here. We want to hear testimony on the bill, and disparaging of anybody is really not very helpful.
Sometimes the truth is not pretty, but
Mr.
that's what I'm...
Santos, please proceed with your
Yes.
testimony
The
on the bill.
other problems is that when they come to the hearings, they're unprepared and outmatched by the defense attorneys, who are prepared to do their jobs. This was all unavoidable. Before the AG was elected, he promised to fix the so-called catch, release, and reoffend program. Yet here we are with the problem seemingly much more exacerbated. It falls directly on his shoulders that we are on this, in this mess. But instead of doing things to fix it, he rather blamed the judges who are just doing their jobs and being umpires, or blame the law, or blame the system. So here are my suggestions to fix the ineptitude and incompetence at the Attorney General's office.
Madam Chair.
Is that on the bill, sir?
I'm
Yeah.
sorry, it is. First suggestion.
Madam Chair, if I may,
Senator,
you know,
did
you
we-
did question it, and again, this is not on the bill. You know, questioning the
Thank you,
Attorney
Senator
General's
Titigan.
office. Thank
Please
you.
proceed, Senator.
This is
Mr.
on the bill.
Santos,
This
I
is-
allow almost all testimony in here, but yeah, thank you. Please proceed
The
and please
suggestion-
stick to the bill.
Is to work with GPD to figure out why they have such unnecessary delays and help them solve their problem of their late report submissions. Have the arresting officer write a one paragraph in the Form GPD-7, which can be copied and pasted as the declaration of probable cause. This will avoid the prosecutor having to read all the reports to attempt to glean all the facts and draft a declaration of probable cause. And also stuff won't get lost in translation and therefore get kicked back by the magistrate. Have the two experienced prosecutors, Sean Brown and Christine Tenorio, train the lesser experienced attorneys to properly meet their burden during the magistrate hearings. I urge this honorable body not to be gaslighted. It's an unconstitutional and inorganic bill, but as a general principle, we should not reward incompetence. You don't ask everyone to change the rules at everyone else's expense just because you cannot meet your requirements. Necesita tafagmata, zatababay matata sa esti, mampus jadi mas, hanadadanyuhit ni publico ni esti na Attorney General. Thank you, Your Honor, or Madam Speaker.
Thank you, Attorney Santos. You can remain for questioning later? All right. Attorney Hattori.
Thank you, Madam Chairperson. Good afternoon. I'm Stephen Hattori. I'm the current director of the Public Defender Service Corporation. Excuse me, I kind of have a cold. Thank you for the opportunity to provide testimony regarding Bill number 235-37. I believe this measure is unnecessary. We have 48 hours currently for the government to charge a case out, and we believe, we believe actually 24 hours is the appropriate time. And the reason why is this: we're dealing with people who've been arrested. What that means is there's probable cause to believe a crime has committed. So there's no reason you cannot allocate all your resources to bringing this person to justice quickly, right? And so I'm not sure why we're even talking about extending it from 48 to 72. We really should be talking about giving victims quicker justice and doing it in 24 hours. I think that office is capable of doing it, and they've done so in the past. Pre-2008, they had 24 hours to charge cases. Let me tell you how many cases were charged. In 2000, there were 1,655 cases charged. In 2001, there were 1,571 cases charged. In 2002, there were 1,746 cases charged. In 2003, there were 114 cases charged. 2004, there were 1,424. 2005, there was 1,425. In 2006, there was 1,608. In 2007, there was 1,702. In 2008, there was 1,812. And so last year in 2023, there were 1,268 cases charged. That's anywhere from 200 to 400 less than were charged during a time when they had half the amount of time to charge cases. And so when you're a victim or you're a public, you know a crime's been committed, you know someone's been arrested for that crime, why aren't we having them charged out in 24 hours instead of 72 hours? Shouldn't we be seeking swifter justice for our victims and for our public? And so we also attached in our testimony, the Riverside versus McLaughlin case. I know that other people have also submitted it. And basically it says 48 hours as the cap, right? You cannot exceed 48 hours. But it also warns the jurisdictions that even magistrating someone within 48 hours can still subject you to a Fourth Amendment violation if the delay is unreasonable, if it's caused because, delay for delay's sake, to conduct further investigation, and also because out of ill will for the person arrested. And I suggest that's the issue. Right now we have panhandlers who should be cited, but instead they're arrested, they're thrown into jail, and they are not brought to court. They're given a notice to appear so that we never get to see them and fight for them in court. So they're released 2 days after on a case that they should be getting a traffic ticket for. During the pandemic, there was a homeless individual. During the Typhoon Marmar, magistrate hearings were continued because of the emergency nature of the typhoon. We didn't have magistrates for over 7 days. So there was a homeless individual who was cited for panhandling, arrested, booked and confined, and he was actually released before the first magistrate hearing, but he was in there for 8 days. And so what this delay does is it prevents outside review of decisions made by the office. And really, if you have enough evidence to charge someone in 24 hours, like they did back before 2008, you should charge them and bring it before the court within 24 hours. And so the Riverside case actually suggests that we can still do that. We can actually make a motion, say that there was undue delay, there was a morning magistrate, he should have been brought before the morning magistrate, and so the case should get dismissed on that basis. And so, we've been raising that a couple times. It hasn't, it requires an evidentiary hearing, so that issue is still outstanding. But to my knowledge, there has never been a case where the government was unable to actually magistrate someone within 48 hours. Yes, they have not magistrated everyone, but they make a decision. Like if you're picked up for DUI, you don't have to be magistrated. You can be given a notice to appear. If you're picked up for a nonviolent offense, you don't have to be magistrated. You can be given a notice to appear. And that gives the government more time to prosecute a case. And then you could focus on the violent offenses, the robberies, the homicides, the aggravated assaults. But I challenged the Attorney General to produce one case where someone was arrested for a violent offense and they were forced to dismiss the case and release them without any conditions. They won't be able to cite one. I know that they have a list of cases that they cited originally, but I don't know if any of those that they had to dismiss. So let me explain. When they say they have to let them out of jail, it doesn't mean the case goes away. They still have a year in misdemeanors and 3 years in felonies to charge them. So I'd like to see those kind of cases if they were actually eventually charged where they claim that they were forced to release them. And so if we have a problem with that, we can give our police officers more authority. We can say like, hey, if a police officer can give an individual a notice to appear that is a misdemeanor offense if they fail to show up, or a felony offense if they fail to show up for a felony charge, then a police officer could give them a notice to appear to stay away from an alleged victim. You know, they could say like, here's notice to appear, and if you violate a stay away from this alleged victim, then you can face a misdemeanor or a felony if it's a felony offense. So there are ways of fixing that problem, but creating a constitutional problem by extending the amount of time from 48 to 72 hours is just going to result in more, let's just say the system will not be, you really want a system that is fixed and not subject to a lot of fighting, right? So we'll be filing motions to dismiss every magistrate filed after 48 hours consistent with the Riverside case. And that litigation could result in some cases getting dismissed, and it may result in other cases not being dismissed. But if we stick to what we know is constitutionally permissible, the 48 hours, or if we go with the absolute gold standard, which is 24 hours, we won't have to be dealing with these motions to dismiss, and the crimes, the cases won't get dismissed. And so we just, ask the legislature, really, we're all anti-crime here. This is actually a pro-crime bill because it encourages more litigation on timeliness, and victims should be allowed to see cases charged faster as opposed to slower. And so we ask the court the legislature to consider that. I don't have anything else to add. Thank you.
Thank you very much, Attorney Hattori. If you could state for the record, your testimony submitted on whose behalf?
Oh, yes, we also submitted written testimony with attached exhibits.
And this is on behalf of the Public Defender Service Corporation?
Yes.
You are the executive director?
Yes,
right.
and I did, part of that is a survey of all the different states, and so, but you have to read the fine print because it's not really 72 hours, there are certain caveats in all of them.
All right, thank you.
Thank you.
Attorney John Morrison.
Thank you, Madam Speaker, members of the committee. My name is John Morrison. I'm the Deputy Director of the Public Defender Service Corporation. I'm going to testify in that capacity. So I just wanted to give everybody a little bit of background about what we're talking about here, because I think there's probably a tendency of myself and Director Hattori and Peter Santos to just start talking about this stuff without giving a lot of background on it because we deal with it every day. But these magistrate hearings, they're basically, the question you should be asking is how many days or hours is it appropriate to keep somebody in jail before they've seen a judge after they've been arrested, usually without a warrant. So currently we use 48 hours as our benchmark for that. Prior to 2008, as Director Hattori indicated, we used 24 hours. And there was a decision in 1991, Riverside versus McLaughlin, that set 48 hours as the outer limit of what is permitted. I would encourage everybody to read that case. It's at 500 U.S. 44, 1991. It's very clear on what is legally permissible as far as holding somebody before they see a judge and probable cause is determined. So what brings us here today is that on January 30th of this year, the Attorney General sent a letter to various stakeholders indicating that there were 4 magistrate hearings that weren't able to be charged out within the time limits. The judiciary acted very quickly with their administrator of courts, Danielle Rossetti, and at the direction of the presiding judge. A huge Zoom meeting was held between all the stakeholders on February 9th of this year. After that, on February 12th, the administrator of the court sent out a letter indicating the procedure that was going to be used. The Attorney General at that point had been asking for magistrate hearings on morning and afternoon. The policy or the procedure that everyone agreed that was going to be used was that if the Attorney General determined that there were any magistrate hearings that needed to be heard in the morning because they couldn't be filed the evening before, because we have these hearings at 3 p.m. every day, except for Sundays usually, that they needed to let the court know by 4 p.m. the previous day. So to my knowledge, that's happened very infrequently since the procedure was agreed upon. Essentially, I think the testimony from the judiciary was that it's happened 4 times. I think that's probably technically right, but I'm not sure that any of those 4 times actually occurred at the request of the Attorney General. I think those were more of things like the magistrate didn't have appointed counsel, so asked everybody to reconvene the following morning. And I'm aware that that's happened a few times. I think that's basically solved the problem. So I would discourage the legislature from passing a bill that I think has some constitutional real limitations and impairments to it. I do not think it would be constitutionally advisable to pass a bill that says 72 hours is the standard that we're going to use now after the McLaughlin decision that says that 48 hours is the standard that is the outer limit of what needs to be adhered to. I'm sympathetic to Senator Parkinson's statement where he said that some jurisdictions require allow for a 72-hour benchmark, but in those jurisdictions there are some limitations to that. Specifically, that those jurisdictions are doing it with a warrant. So the outcome there is that a judicial officer has already reviewed the case for probable cause before the arrest was made. What we're really talking about here is taking an individual who's been arrested without a warrant to a judicial officer before a determination of probable cause has been made. So it's sort of happening in the reverse, and that's the difference there. I'm happy to answer any of your questions. I think we've taken up enough time on the issue, but if you have any questions, I'm happy to help.
Thank you, Attorney Morrison, Deputy Director at Public Defender Service Corporation. Attorney General Moylan.
Thank you, Madam Speaker, and good afternoon, Senators. The bill that was introduced at our request, as it was pointed out, was a bill that was crafted at the same time that a letter had been sent to the Administrator of the Courts dated January 30, 2024. Let's make this clear. The criminal justice system does not just include the Attorney General's office. A lot of the disparaging comments that were made by the first speaker were disparaging the Guam Police Department. The Attorney General does not go out, nor do any of my attorneys, and pull over people that are on drugs, go to a family violence house, and arrest people. It's the Guam Police Department. The statute as it exists, and if we jump to the chase here on the Riverside case, the statute as it exists right now, under their analysis, is already in violation of the U.S. Constitution and the Riverside decision, the 1991 case that they're citing. It specifically indicates that the person arrested shall, in all cases, be taken before the judge within 48 hours after the arrest, except that when the 48-hour period expires, it is the burden of the government to demonstrate that a bona fide emergency or extraordinary circumstance existed. That's excess of the 48 hours. So the 3 speakers that just spoke before you have indicated that the current statute is unconstitutional, because it, by definition, already says that if it exceeds 48 hours, the government attorney can go and make a case that there's an emergency situation that has existed. okay? The senators already recognize that there are states that have passed the 72-hour requirement. That's what we're here for today. We have situations that are going on, and I can't speak to the statistics specifically, but I know that one of the statistics that was going by year, identify those cases, not that were filed, but the cases that went before the magistrate. That's the key question here, because we got the cases where there's a book and confine, and then you got the book and release, which deals with paperwork that comes before the AG's office. We call it the green sheets, and they look at and they charge. That's not what we're talking about. That adds or takes away from the final figure for that period. We're talking about the ones where the Guam Police Department, normally or Customs, or some law enforcement agency decides to arrest a person. That starts the clock to tick. So you've got from then to the end of 48 hours to bring that person before the judge, not to file it, where you get the stamp on it, but actually bring that person before the judge. Since I've been the Attorney General, there's been more cases that this is the second time around, more cases that the Guam Police Department are sending over to the AG's office. We see from anywhere between maybe nothing, which is rare, to a few, 3 or 4, to I've seen as high as maybe 17 arrests. So that requires, obviously, the AG's office to vet them, to review the police reports, and so forth. The problem is that in some of these big cases, whether you're talking about a murder case or a criminal sexual conduct case, or even a burglary for that matter, they're coming up with 10 different police reports. The Guam Police Department arrests somebody at a certain time, but hasn't sent the reports over to the AG's office. Now, of course, that can be done properly, quickly, whatever you want to call it. But the situation that we brought before the court in the January 30, 2024, was that the court was only doing 3 o'clock magistrate hearings. We had asked them informally, and actually I met with them, I think 6 months before, and it's in the letter, to ask them to at least have a morning one so we could capture the 48 hours. They didn't do anything, so we formally did it, and we cited 4 cases where it actually fell out of the system, where a person was arrested, and we couldn't get it before the 3 o'clock magistrate, that individual, so they had to be released. But yes, we indict them quickly after. We have a system for that to make sure. But this is what happens in a situation like that. Take, for example, a family violence. Police come over, the defendant, the suspect, is about ready to kill the person for whatever reason. Gets arrested, expected to be taken before a judge, doesn't get brought before that judge within the 48-hour period, person gets released, person gets killed when they release the suspect, the detainee, because they're not a defendant until the judge accepts the criminal complaint. That's the situation that we're dealing with on violent criminals, the what-ifs. So even though we may be able to indict them a certain time, there's no court order over them, or they're not being kept in jail. So that's the worst-case scenario. And so what, do we do what the other attorneys are saying and blame somebody else? Do we blame the police department because they kept them too long, so we only had 10 hours to bring them before a judge who wasn't on the bench? We have no ex parte proceedings in the court. We can't call up the judge at 2 o'clock in the morning and say that we've got a defendant that has to be brought in by 6 o'clock that morning, otherwise he's going to be released. There's no procedure that allows for that with the court. So, you know, these are internal workings. The court has accommodated us. They did allow for the morning hearings. Okay. The problem we're now facing is that you've got somebody arrested on a Saturday. The idea was at 3 o'clock in the morning, arrested on the Saturday. Doesn't make it to the Department of Corrections morning list, so the AG's office doesn't see it on the list that comes from DOC. Or a situation where, how do we put this, the DOC has made mistakes. They update and amend their listing, so they don't show it. They send it to us literally on a Sunday when nobody's working, and that's kind of like the court doesn't work, the AG's office doesn't work on a normal weekend. That person cannot be magistrated even by, I think it's the 9 o'clock or 10 o'clock time that they're allowing for in the mornings, the morning before. So you're getting a loss of individuals that, for whatever reason, are not able to be magistrated, even if I had a whole fleet of lawyers. And let's how do we say, digress a moment. No one of the speakers before me mentioned to you, Guam has a lack of attorneys. That is common knowledge. That has been made part of promulgation orders of the Supreme Court of Guam, saying that the indigent panel no longer has sufficient lawyers, so every private attorney on Guam is being tapped in to be an indigent defense attorney. and is the reason why, in my opinion, that the 5-year temporary license requirement was extended in 2023, last year, to allow for 8 years for off-island barred attorneys to be practicing in this jurisdiction. So, you know, the Riverside decision that's being cited as the primary reason why this should not go, this statute should not be passed, or this bill should not be passed, I think is going to require further legal analysis. And I have my attorneys here that are going to provide the committee the legal analysis on the Riverside case and the jurisdiction, showing how other jurisdictions have provided that 72 hours is allowable. Also, Senators, from what I was listening to, it seems to be saying by the other speakers that we wait till 48 hours to charge somebody. It is not in our best interest to delay at all when receiving that police report and immediately filing it to make the magistrate's hearing, because you're just making it worse for all the other detainees that are going to be constantly arrested for the following day and so forth. So upon these cases being received by us, we immediately work on the magistrates and we file it, and then we try to get the case before a judge. So those are some of the nuances that I think weren't pointed out to the senators in the testimony. But I think clearly the rule is not 48 hours, period. The rule has exceptions to it, and I welcome working with the committee to craft possibly a slight amendment to the overall 72-hour requirement. But I do know under our existing statute, I've never heard of any attorney general bringing that, exceeding the 48-hour requirement under what the statute says, where it says that it is the burden of the government to demonstrate a bona fide emergency or extraordinary circumstances existed. Again, if Riverside says 48 hours, that language is inorganic and in violation of the Constitution. So, having said that, our office is working on a team of a special unit of prosecutors that will be fully dedicated to this task, but we will not be able to capture the situations on the weekends. And I think when we had this Zoom meeting with the presiding judge, he specifically said that the fix was only intending to focus upon the weekdays. We have a need that potentially we're going to need an ex parte judge to be dealing with these special situations where the Guam Police Department makes an arrest and doesn't get that person delivered to the Department of Corrections and then the AG's office notified. It's happening, okay? Renita Nicholas, the experienced prosecutor that was probably 3 attorney generals before, as the first speaker seems to enjoy bashing the AG's office prosecutors, has been part of this process for at least 1 attorney general before me. And she herself recognizes that the numbers are going up. The inability to timely process these people requires some adjustment in the law, and that's the situation we're dealing with. The statement about the Guam Police Department should also be recognized that we are often getting officers that, because criminal sexual conduct cases, murder cases, things like that, these officers are literally working more than, at a 24-hour pace, the detectives, in order to put the case together so it can actually be charged. So it's not in the AG's office that a lot of these problems are occurring. It's the fact that, and the first speaker alluded to it, the police reports are not coming to the AG's office in time for us to file it. Count the numbers, 8 o'clock to 12 o'clock. You got 4 hours to process up to 17 defendants, and that requires looking over the police reports, checking the charges of which be charged, creating the affidavit of probable cause, and if you miss 1 or 2 of them, it could mean the life or death of somebody. So what we're basically saying is create the latitude, the bandwidth within the statute, in the confines of Riverside and whatever other laws are out there, to allow for the latitude to properly charge, to vet and charge everyone that should be charged. Because remember, of the 17 example or the 14 example, probably 5 or 8 of them may not be charged at all because lack of probable cause in the police report or decision that this case should not be charged. The ability to actually sit down and vet requires time. We're talking 4 hours. And our average right now is 5 police reports for 1 prosecutor, and that's pushing it. to prepare all the paperwork by 12 o'clock. Now, 12 o'clock, the only reason why the court's required at 12 o'clock, because they want 3 hours to prepare for their judge, the magistrate judge, to have the 3 o'clock hearing. So we're rushing everything within literally a period of 48 hours, and it's not just the Attorney General's office. It's the law enforcement agencies that are starting the process. So I look forward to our office working together with you, Chairman Parkinson, as well as Madam Speaker, to, during this time before you finalize this testimony, to address the Riverside case and maybe come up with a bit of tweaking. I'm not saying that this is a perfect bill, but it's a good start to make sure that this community remains safe. And I think that, and I applaud the other speakers' comments, that we all want a safe community. We all want a law-abiding community. I recognize the fact that we have to provide the indigent and those accused of that right to their innocence. And I think the time's important. And it doesn't mean that we're going to be using that time to charge them, but it'll be using the time to ensure that an actual crime occurred and that the criminal justice process begins. This is the beginning of the criminal justice process in the courts, is the magistrate hearing. Thank you.
Thank you, Attorney General. Sorry, ma'am, I don't have your name on the list. Did you want to testify as well? Sorry, turn on the microphone. No? Yes? Okay.
Thank you, Madam Speaker. This is Ms. Lita Womack. She's one of the many new prosecutors that we're bringing into Guam pursuant to the Supreme Court of Guam's allowance for these temporary licenses, and she's one of the people that the first speaker is disparaging. Thank you.
Thank you. All right, so I'll ask the sponsor if he has any questions for the panel.
Yeah, I do. Just for the folks on the public defender side, because I know there is a little bit of a rub with this 72-hour change, because in the jurisdictions where there is 72 hours, there's very strict and specific scenarios for when that 72 hours comes into play. As a general principle, would you be more comfortable with this bill and this language and the direction it's going if it mirrored some of those very limited windows for 72 hours, like in the stateside jurisdictions?
Well, I mean, obviously, if a magistrate has found probable cause to issue an arrest warrant, then that the Riverside case isn't necessarily applicable. But we're talking about situations where there is no probable cause determination by a magistrate. So, if there is an arrest warrant, then I don't think you need to do it within 48 hours. I think you could do it within 72 hours.
And so just so I understand your position correctly, that if these specific conditions similar to stateside cases that have 72 hours are met here, it's your position that we don't even need to change the laws to go beyond 48 hours if we have things like probable cause already?
Yeah, that's correct. And then, unfortunately, we don't really see arrest warrants, right? We see these things saying like, this person is wanted for information. And really, if you have enough evidence to get an arrest warrant, GPD should work with the AG's office and get an arrest warrant. And then if someone interferes with this arrest warrant, you could charge them with interference with investigation, right? But if someone's just wanted for questioning, there's no law for not responding to that, But if there is a warrant for an arrest and you actively prevent someone from executing that warrant, you could get criminally charged. But if, GPD issues a press release saying, I want to interview Steve Vittori for questioning, I don't have to abide by that because there's no probable cause determination by a magistrate. So I really wish they would issue arrest warrants, and that would eliminate the 48-hour, 72-hour requirement, but it's not a practice that's currently employed. I mean, you see with the tourist case, or these other cases where they have suspects in mind, like the recent kidnapping case. They had suspects in mind, but they didn't get an arrest warrant. If they had an arrest warrant, 72 hours would be fine.
If I may, Senator, Mr. Hattori mentioned something that if we do go to the 72-hour period, it's just going to invite further litigation. And we already have a shortage of attorneys as it is, right? And the other thing is, but to answer your question, if crafting the bill differently would make a difference, well, the current bill just changed one singular word. So, of course, adding to it would probably make a difference.
Senator, I want to answer the question, and I will tell you that this is Riverside versus McLaughlin at page 57, just for the record and for your legal counsel. This reads, quote, where an arrested individual does not receive a probable cause determination within 48 hours, the calculus changes. In such a case, the arrested individual does not bear the burden of proving an unreasonable delay. Rather, the burden shifts to the government to demonstrate the existence of a bona fide emergency or other extraordinary circumstance. The fact that in a particular case it may take longer than 48 hours to consolidate pretrial proceedings does not qualify as an extraordinary circumstances, nor for that matter do intervening weekends. A jurisdiction that chooses to offer combined proceedings must do so as soon as it is reasonably feasible, but in no event later than 48 hours after arrest. So that is Riverside. We are currently Riverside. We're right in line with it. We say there's some exceptions if there's a bona fide emergency. That's our current law. That's if there's a shootout with law enforcement and the defendant gets shot and is in the hospital and is on life support, we don't have to take that person to the magistrate within 48 hours. There's a bona fide emergency in that situation. And there are other circumstances that would be determined by a judge. But currently, it can be extended up to 72 hours based on what we have in Riverside. So I don't think that there is the need to incorporate this. You could change it to say that, like Director Hattori was saying, if there was an arrest warrant, then there's already been a probable cause determination, and we could take it to 72 hours without any real difficulty there. But I would discourage you from passing one that just says 48 hours, that says 72 hours is our bright line, because you're going to be in conflict with this case, and it's controlling.
I see. And so I'm just trying to understand, because I'm hearing some testimony that is saying that, you know, there's already case law that would allow for cases to go 72 hours, but I'm also seeing that there's legislation in other states allowing the same thing. And so I guess I'm just trying to understand, for even those acceptable cases where we shift it to 72 hours, is legislation necessary to achieve that end state of 72 hours?
If that's for me, I don't think it's necessary in this jurisdiction. The jurisdictions that I looked at, the Georgia, the Alabama that you referenced earlier, in those jurisdictions it's specific that 72 hours is permissible if the arrest was done pursuant to a warrant. What we're really talking about here is your run-of-the-mill case where someone is arrested. The first person they see to make a probable cause determination is at that magistrate hearing. So you could add language that says 72 hours is fine if there is already an arrest warrant, but that's really an underwhelming amount of cases here. I don't know that I've really ever seen somebody brought in pursuant to an arrest warrant. It's almost always they were brought in for questioning. The police arrested them and took them to the magistrate as soon as they could, usually always within 48 hours.
Thank you. Madam Chair, I have no further questions.
Thank you, Senator. I have a couple questions. First of all, thank you all for your testimony. I very much appreciate the professionalism in some of them. Attorney General, do you have statistics where, does your office keep statistics regarding number of cases referred by the Guam Police Department versus the number of cases that are actually filed or that you pursue? And like, does it keep, you mentioned some reasons, for example, no probable cause or other.
Right.
you keep those statistics?
I don't know how well we're keeping them right now. We've got the old JustWare system that we finally procured, and their representatives should be here probably, I think, within the next 30 days. I hired the IT person that's integrating our JustWare e-prosecutor coordination with the court's e-prosecutor. So I will work on those statistics. It's something that we've been discussing on a daily basis on uploading our information, getting the statistics that you're requesting. That's very important to me as a Attorney General, working with my acting Chief Prosecutor, Gloria Rudolph, and the IT team. So I'll have that looked at and see what data we can provide to you, Madam Speaker.
All right, I remember trying to pursue this before, so we can get from GPD the number of cases referred by
To
them
us.
to your office?
Yes.
But there's nothing that put them together, yeah. So how many cases you've prosecuted? I guess you're saying that the statistics and the public defender's testimony showing cases filed are not necessarily cases that were involved arrests?
Yeah, the bill that we're talking about is only to those that are booked and confined. The detainees, we call them at DOC, they get sent to the AG's office for processing. The total number could be those that were just booked and released, or a police complaint that was sent over to our office where nobody was booked, and then that's a separate type of charging that occurs, whether it's a misdemeanor or a felony. We call it the green sheets.
All right. And then I'm just curious for purposes of the recommendations that were given by Attorney Santos as to, you know, how to work with GPD and him pointing out that GPD reports sometimes are transmitted to the AG's office at 11 or 1 p.m. when the deadline is 12 p.m. for the AG's office to the court. And other purposes, I think, relevant to us to see, yeah, what is the correlation between GPD's arrests or
Yes.
cases and versus the Attorney General's finding.
And this has been going on for decades, ever since
Yes.
I was the first elected AG in 2003, even before that. But I mean, the relationship and the rapport that we law enforcement must maintain with one another not only includes that, but you literally are getting those cases where they have been working so long that the officer cannot physically go into his LERMS computer to upload the documents into the LERMS system. In those cases, we can call the officer, and the affidavit probable cause can be comprised based upon the call-in. So we're having these, it seems to be like more than 20% of the cases now are having that they're not ready at 8 o'clock. Okay, so we're working on that right now. The logistics of it, it's really logistics on getting that to work properly. But every case, every charge, every arrest is different in nature. You're getting arrested at 3 o'clock in the morning, you're getting arrested in the mornings, the afternoons. So that's why I say we're targeting now the Saturday arrests that are occurring, because we're working on Saturday from 8 to 12 and then appearing for the 3 o'clock magistrate. The court set up a procedure that if we can't get everybody ready by the 3 o'clock magistrate, we got to give them notice by 4 o'clock, file the documents, and then be ready for the next day's hearing. But the problem is there's no Sunday magistrate hearing. That's why, again, Presiding Judge Lamarena was just saying the procedure was going to cover the Monday to Friday situations. So I have my chief prosecutor is supposed to be working on another letter to the the presiding judge, the administrator of the courts, to address the Saturday problems that we're seeing. So that's where we're at, Madam Speaker.
All right, thank you. And then so the court has worked with you and
Yes.
come up with a procedure to allow for morning magistrates on request of the AG, but it requires a 4 p.m. deadline the night before that you notify them. That means you must,
Have it filed by 4 o'clock.
you have to
plus
file the actual complaint.
Right, we have to file the actual complaint. We have to be physically present. I'm going to send a letter to the presiding judge. Why are we having to be physically present versus doing in Zoom, where my prosecutors could literally be working on the next case as opposed to the transport time, going down to be physically present. The presiding judge said that both sides would have to be present. Now we're finding out just the prosecutor has to be present and the other side could do it by Zoom. Those are logistics things that we're trying to smooth out. Remember when I first sent the bill over, we didn't have that morning opportunity, and the court was very responsive to it. Now we're dealing with the Saturday problem, and I've already got statistics of people that have not been able to be charged because it's outside the 48-hour window. And whether or not it's DOC's fault, whether it's the Guam Police Department's fault, or even our fault, there's this problem, and it's got to be fixed. To use the tail end, or whatever the Riverside case provides for the exceptions for the 72-hour requirement, I think it would be a good tool for our law enforcement, both Guam Police Department, Customs, the AG's office, and even the courts, you know, to have that latitude. Because the law, as I said, it already allows for exceeding 48 hours. Whether it's because a person is in GMH, which I've never heard of before being ever used for that, or what is an emergency? You know, do we want to litigate that matter up because the defense attorneys will bring it up, or not? It's just to make the statute clearer and to follow the constitutional requirements as set forth by the U.S. Supreme Court and these other states that are exceeding 48 hours on their way of interpreting the Riverside case. Thank you.
All right, so I can see the courts, they need the copies of the complaint in order to give it to the defense counsel and other parties, the magistrate himself. But is this only for, well, and then, so for morning complaints, for morning hearings, they want the complaint by the 4 p.m. the night before.
Correct.
And for same-day hearings, they will all take place at 3 p.m. They want the documents
By
before 12 noon.
Right, we have 4 hours, 8 to 4.
Right.
So
And so they say in their letter to you that
Yes.
All attorneys are required to attend in person.
Which is not the case
Declarations
now.
of probable cause must include a record of the time of arrest. So, but you're saying this is not necessarily what they're
Well,
using?
they've changed it because we asked at the
Okay.
Zoom meeting not have to be
Okay.
in person.
And what about, it says also that the 4 p.m. deadline is critical to provide the judiciary sufficient time to notify parties and to have the matter appear on the publicly available court calendar on the website. Does that happen on the same-day hearings, that it appears on the court calendar if you submit it by noon? The court calendars are
No.
issued in the mornings,
No.
right?
No.
All right. What is the process when, Attorney Hattori, you had advocated that we should be getting warrants, like warrants of arrest? However, are they able to go in for a warrant of arrest without this type of process, advance notice to the court, 3 hours in advance,
So,
and 1 day before?
It's the same procedure for getting a search warrant. They just
Same.
have to go before a judge and establish probable cause, and then an arrest warrant would issue. And then because there's been an independent probable cause finding by an independent magistrate, then they can be held for up to, I think, 72
Right, I'm just
hours.
asking about the process, though. So for arrest warrants, they don't require all that advance notice. So do you know why they?
The logistical problem with that is GPD officers aren't going to pull over a guy with PCS, say that, wait, give me
I know.
3 hours.
No, I understand that part. What I
So-
want to know is, on the court side, they don't, they allow you to just come in to request arrest warrants and without all this advance notice like they're requiring for these magistrates?
A lot of the warrants are from Guam Police Department directly with the judges. So they have a protocol that's set up there. Our prosecutors don't normally do those things, but there is a process for it. It's just logistically would be almost impossible to administer, I think, like this. Just like the preliminary hearings. It's in the statutes, but we don't do it because logistically we don't have the lawyers, you don't have the time. The judges don't appreciate it because their calendars are very busy. So we use the indictment instead of the preliminary hearing.
All right,
For
so
the
who goes
warrant-
in for the arrest warrants?
Usually-
Not the Attorney General, you said?
Not
So who-
normally. It's the police officers.
Okay.
They apply to the.
So, yeah, do they have to give advance notice or they just go in?
They usually call. I believe there's a judge always on call
Supposed to be.
receive those. Yes.
Okay. All right, thanks. Senator Lujan, any questions or comments?
Yes. Thank you, Madam Chair. Good afternoon again, panel. I just want to cut to the chase here and just ask this question because this bill passes and forwarded to the governor and either signed or lapsed into law. On indication here that it will be challenged?
I believe that it probably will be challenged
okay.
because of the way that these things are crafted, but that's how you get good law
okay.
as well. It could probably sustain it, and that's why I want the opportunity with my team here to incorporate these comments that are being made to us today to make sure that we get a well-drafted statute within the confines of the Constitution and to protect this community. Ultimately, we're here to protect those victims out there that the police are protecting.
Okay. And I know that you said the bill wasn't perfect, that you, of course, looking at tweaking it.
Yes.
Okay. And the reason why I'm asking this, because the testimony that the judiciary had put out, and the reason why I'm saying, you know, we challenge, and then, of course, the courts will decide, okay? Because, again, in their submission of their testimony, it's a potential constitutional concerns. And then, so they've already pretty much put out an opinion. And they said, we also respectfully know that all of the bill states that other jurisdictions do not require 48 hours to be absolute dateline. Only 3 jurisdictions have a 72-hour timeline in their statute, and these are under specific conditions. For example, Georgia permits 72-hour period only if there is an arrest with a warrant. Otherwise, the period reverts to 48 hours, in line with the Supreme Court's mandate. So they're pretty much, when it goes to the courts, they've already pretty much made their decision.
Well, as we all say, then I think this, I've been before a public hearing in the past, when the court sends a message to the legislature, you need to read it, right?
Yeah.
So I do believe, though, that the Supreme Court of the United States, the Supreme Court of Guam, you make the right argument before them, and I believe that there's room for development of any exceptions, as Danielle Rousset, who's the administrator of the courts, has indicated in that letter, that this has come up before, this has been their position, there is a U.S. Supreme Court case on it, but it's not set in stone. There are exceptions that even our court is recognizing. A 72-hour framework is possible. That's what that letter says to me. We just got to make sure that we're following these nuances that are contained in there. But again, our current statute is unconstitutional if you kind of look at it, because it says if you don't make the 48-hour on an emergency basis, you can get an exception to it. That's not what the court said. So in that letter, they should also cite that the current statute is unconstitutional as it pertains to anything past 48 hours. Because they talk about an emergency in our current statute.
Senator,
That's
if
all
I
I'm
may.
saying.
In its current form, the statute would be dead on arrival at the courts. If you change it, tweak it, then there may be room. But subsection A addresses what the Attorney General is talking about, and subsection A does not make subsection C illegal. So that's incorrect. Subsection C, our current statute is not illegal or unconstitutional.
It is the burden of the government to demonstrate that the bona fide emergency or an extraordinary circumstance existed to exceed the 48 hours. So what, I come in 3 days later, 5 days later? The law is vague as it relates to the Riverside case. It doesn't say up to 72 hours you can come in under certain exceptions. So with all due respect to the speaker, I don't think he's in any position to say this is constitutional or unconstitutional. I think that it has enough, given what I've heard about the Riverside case, to show that the current language of the statute has serious concerns.
So in your opinion, and to tweak the bill, how again, what corrections would you make, or what additions or deletions that you would make to the bill to make it more palatable to, again, fit and be in the realm of being constitutional?
Senator, I'm going to have that legal research done to make sure that we're not speculating here. I want to make sure that my prosecuting team, my legal research team, looks at this carefully. I don't like to take this too far. If it's clear that you can't go past 72 hours, then we'll determine that with legal research. And maybe some of those jurisdictions that we're talking about had it tested to their Supreme Courts, and that we'll review that type of vetting that went on the appeal process and what their Supreme Court reasoned in light of the U.S. Supreme Court.
Okay.
I suspect they've already gone through challenges themselves.
Okay. Thank you, Madam Speaker, or Madam Chair.
Thank you, Senator Lujan. Senator Burnett.
Thank you, Madam Chair. I'd like to thank the panel for their testimony. It's just sometimes hard to sort through some of this testimony when it's just laden with, yeah, it's pretty juicy, actually. So, I'm not an attorney, and it's hard for me to take into account testimony that's, veering off into character assassinations and character attacks. So I'll just tell you what I see. I see, first of all, the Guam Police Department working very hard. I know we had the chief in here last year, and given the current situation with the crystal methamphetamine epidemic, he had said something like, we've increased the number of drug arrests, right? So they're doing the work. They're out there, they're arresting the same 2,000 crystal methamphetamine addicts who are going to court, and they're coming to court, and they're on pretrial release for a felony. We've been through this, right? And then I see an island that's short of attorneys. They're so short of attorneys that we have a sitting senator who runs over to the courthouse to defend criminals and alleged criminals. So that's how short we are. So when I add those things together, what I see is maybe a system, an attorney general that might need an extra day just to get people in front of the judge. And I'm not so opposed to that, and it does kind of sound, again, wading through the different testimony, it does kind of seem like there is a way forward with this. And so that's just my observation. Again, I'm obviously not an attorney, but I do note that we are in a unique situation that our island has never been in. We are being overrun by crystal methamphetamine and drug-related crime, and we're dealing with many people who have gone from being able to be described as addicts to people who have become hardened criminals and who have fell victim to the psychosis that crystal methamphetamine brings with the long-term usage. And again, I talked to a lot of the officers, and they are arresting the same people over and over and over again. And so, forgive me, but having to sit in that cell an extra day, I just don't see it as the affront to the Constitution that it's being portrayed to be. And again, I think that based on the things that I've heard here today, that there will be, or there should be, a middle ground and a way forward to accommodate these unique circumstances that our island's facing. All in the name of justice. So that's just my comment, Madam Chair. Sidus Masi.
Thank you, Senator.
Sidus Masi. Senator Barnett. Senator Taitzigui.
Thank you, Madam Speaker. Thank you for the panel for testifying. Attorney Morrison, I thank you for explaining it that way, the story, going down the history, so that we can kind of understand what exactly the 48 hours versus 72. You've always been good at providing a good explanation, because we're not attorneys, and we don't deal with this on a daily basis. So I appreciate your comments that you were made. However, there is one I'd like to ask Attorney General Moylan. I'm reading this printout that was given to us on different states and their citations. And it said that the person arrested shall, for Guam's jurisdiction, the person arrested shall in all cases be taken before the judge within 48 hours after the arrest, except when the 48-hour period expires. It is the burden of the government to demonstrate that a bona fide emergency or an extraordinary circumstances existed. So I think I heard it earlier that in certain circumstances, they can allow for them to be held longer. Is that true? And is that on the books right now?
That's exactly what it says right now.
Okay.
And it doesn't even put a parameter on it. If the person's in, with my esteemed colleague here saying that if they're in the hospital and they're in the hospital in a coma for 4 days, does that fall within this and allow that?
Right.
Under the Riverside case, I don't think that would allow it. But this is what I'm worried about, these vague statements in the statute. I would prefer that they be clear and consistent with the Riverside case, so that it doesn't need to be challenged.
Right, interpretation, and everyone has a different side of their story, but I agree that the bill needs to, or the law needs to be tweaked in some way to make it clear and precise and to allow, certain circumstances to avail itself. Director Torrey,
Yeah, just like
You-
the way it worked out in Typhoon Marmor, right? We went pretty much 7 days or 8 days without a magistrate hearing. And that was due to it was a bona fide emergency.
okay, Director Torrey, did you sanction? I mean, Mr. Santos came here testifying on behalf of the Public Defender's Office. And did you sanction his testimony, the comments being made that certain comments about naive, gaslighting, disrespectful, Korea, well, that was just brought in North Korea, no experience? Are you sanctioning this testimony? Because it says it's coming from the Public Defender's Office, and that you, sir, are the director of the Public Defender's Office. So are you sanctioning this testimony with all these comments? Because not only, Director Torrey, that it attacked the Office of Attorney General, their character, and the Guam Police Department, but it also attacked this body by calling the author of this legislation dishonest and naive. Now, you've been in front of me many times, and never has it been so disrespectful from this office to come in front of us and say something. So I want to know, are you sanctioning this testimony by Mr. Santos?
Clearly, the views and expressions expressed by Mr. Santos belong to him and him alone. I know we may...
Well, that's not what he says. He's representing the public defender, and that's you,
He
sir.
actually works at the alternate public defender. But notwithstanding that, I think, each individual speaker has the right to say what's on their mind, and I don't think that I'm in any position to...
As an individual, yes. As an individual, if they come and testify. But when they're putting the name of your office on here, then you're the one that's responsible. You have to sanction this because it's coming from you. You might as well put your name on that testimony and not his.
I think he actually clarified that he's actually with alternate public defender, which is not...
And you have nothing to... Well, do you agree with his statements? Naive, calling this body naive? Disrespectful, dishonest?
I don't agree with all of them, Your Honor. In fact,
Okay, that's all.
The hiring of Lita Womack, a former public defender from Montana, I think she's a great addition to the office, and we look forward to her helping the people of Guam. So we don't necessarily agree with everything.
So who's the director? I don't know what's wrong with my microphone, but who is the director of the alternate public defender's office? Who's the director?
That's Miss Annie Gale. Likewise,
And is she sanctioning your testimony?
I told her I was coming.
Okay, but is she
give
sanctioning
testimony.
it, is what I'm asking?
She did not see
So
my
you should
testimony.
not be putting your name, the alternate public defender, without her permission on
But
this.
just to clarify, I did not...
Because you're making it sound like you're coming from there,
I
that's
did
what I'm
not call
saying.
any senator naive.
For the record. It was stated for the record that
Yeah.
your testimony was on behalf of the alternate public
Yes,
defender.
it was. I got clearance from my boss to come down and testify. The author of this bill, I did not call the author of this bill, or I did not call Senator Parkinson naive.
It's on here,
proffer
it's
of
on your
this bill,
testimony.
The author of this bill was Doug Moylan.
Attorney Santos. Senator Taichkui, you have the floor.
It is here, I'm reading it. You know, this is going into the record. You
Yes.
submitted this testimony, it's going into the record. So you
Doug
did
Moylan
say,
gave this
you
bill to
called
the
him
senator.
dishonest and naive proffer of this bill. And that he's
Well, I'm
gaslighting.
clarifying that it's Doug Moylan who pushed this
that's,
bill.
I realize that, you have a hair to pick with the Attorney General's office, but there's no need to bring it in here. Fight your fight where it needs to be fight, but not in this, it's very disrespectful
Understood,
what
Senator,
you did.
but the truth...
And for you to come out,
This is...
I didn't ask you a question, Madam Chair. I'm making a point here,
Understood.
and it's very, very unprofessional to do something like that. Thank you, Madam Speaker.
Thank you, Senator Taichkui. Senator Paris.
Duzmasi, Madam Speaker. So if you can clarify, I know in our current statutes, it states that should the 48 hours expire, it's the burden of government to demonstrate a bona fide emergency or extraordinary circumstance exists. So what's the standard for a bona fide emergency? I know we talked about malware, that's pretty obvious. Extraordinary circumstance, so is there any standards at that's generally accepted?
Senator Perez, I may not agree completely with that statement that the emergency was Mawar. The judiciary of Guam, through order, suspended all timeframes. So I don't think that they may have specifically, although I think that this might be consistent with the way it was worded, but I think it goes way farther than the Mawar situation. Mawar was unique because there were a lot of things that the judiciary of Guam had stopped because of our island emergency. But I mean, this is the danger of these type statutes, that if you don't make it clear, consistent with the Supreme Court of the United States, you're just asking for a lawsuit. That's why we've never used this or tried to use it, because you're just asking for trouble from an AG's perspective, saying that this is an emergency because the officers couldn't get us the report because they were so burned out that they were investigating this for such a long period that they couldn't get us the report, sort of thing, or we couldn't get a hold of them because they were already knocked out. And that's the type of situations that I've seen it going on. So if we're going to amend the statute, that we allow for as much time as the law allows, with all the exceptions that have been appealed and vetted through the judiciary from whatever state that the senators might wish to adopt. And the ultimate goal here is that Senator Parkinson introduced this bill to protect the victims, to protect our community out there. This is what this bill is all about. You know, as Senator Barnett pointed out, there is a meth epidemic, and it's getting worse. People are dying, literally, from the meth addicts. So, thank you, Senator. There's no definition in this statute on what is a bona fide emergency or extraordinary circumstances.
Senator Perez, you asked the question in general. For the court, the standard is... She asked the question in general.
Attorney Santos, she will ask who she wants to ask the questions of, so if she asks you, you will be recognized by her.
Okay, so just for clarification, what is the Supreme Court, what was their ruling? Can you just maybe restate that? What was their, so I'm trying to see how we can align with the Supreme Court ruling more closely, because Attorney General, you're saying that this is not aligned with the court ruling, is that correct?
No, I'm saying that because the Riverside case has been cited, I would like the opportunity to have our lawyers research it and provide during this public testimony period, and I'm talking the next few days, by the way, to clarify these three, I guess there's 3 states that were mentioned that allowed the 72 hours, but they put certain caveats on it. I need to research how they got to that conclusion, because we did the research when we sent it over to Senator Parkinson. Actually, a copy to the court was attached to this original letter, just to confirm and to clarify, to make clear, so that the committee can consider whether it wishes to amend the current bill.
Okay, so, but in the ruling that you were citing, it stated that it's the burden of the government to explain why they're going beyond 48 hours, is that correct?
Right, this is our current statute. I just read from what is it's in the code under HGCA 4510.
Yeah, so I have the bill in front of me. Yeah,
right,
so,
D, C?
so I just need clarification. What does the court ruling say? And I guess maybe how do we align closer to that?
Right, I need to scrutinize it better. There's comments that it can be done in an arrest warrant situation. I'm not so clear on that, and I have to make myself clear. Okay. That's where I have to. So
for the courts, Attorney Morrison, you mentioned that the timestamps of 48 hours was developed. Do you understand how they came to that timestamp?
I do. There was this whole thing where I read an excerpt into the record, and I think if you went back and looked at that portion of it, that may answer some of your questions. It's at page 57 of the McLaughlin case. It's talking about specifically that it's constitutional to hold somebody for 48 hours. If you do it any longer, then the government the AG's office in our situation has to come forward with an explanation of a bona fide emergency of why they were unable to get that person to the judge within 48 hours, or the magistrate within 48 hours. So I think that case at that particular page will answer all those questions. It says specifically that this has to be things that are outside of just the normal course of activity. This can't be, well, we didn't have, the police report didn't come to us in time, or we didn't have enough attorneys. I don't think those are going to be the sorts of things that are looked at as extraordinary circumstances, because those are just general systemic things. This has to be something that's a bona fide emergency that we weren't expecting, something like a typhoon, something like the defendant is gravely ill and can't see the judge in time. Something like that, I think the court would look at and say that's a bona fide emergency. These things that are just normal course of business, not so much. And I think if you went and read the case, I mean, it's actually quite an interesting case. There's this push and pull between the majority and Justice Scalia, who writes a dissent in the opinion. And Justice Scalia's conservative position is actually that these magistrate hearings or these first appearances or these probable cause determinations should take place actually much faster, that they should take place within 24 hours. They should take place as quickly as possible. And that's the conservative opinion of the court. The majority opinion sets a slightly different course and says that 48 hours is really acceptable. This is a careful balance of interests. And actually, if you do it within 48 hours, that is the standard that we're comfortable with. That takes into account law enforcement and defendants' rights at the same time, and that's what the standard is going to be. Justice Scalia was critical of that in his dissent, and he basically said that, well, the majority has no problem breathing life into constitutional rights that aren't clear on its face in the Constitution, and actually they're diluting at the same time a constitutional right that is clear on its face, this Fourth Amendment that would require somebody be taken to a neutral magistrate within this amount of time.
And also, could I just add that the U.S. Supreme Court then went
you may
further.
proceed. Yeah, I was going to ask,
Oh,
you were
sorry.
next, coming up next. I was just wondering if this is like a habeas corpus related kind of thing.
Yeah, so the Supreme Court went even further and said, even if you magistrate within the 48 hours period, and it's done so due to that you use the whole 48 hours for delay, ill will, to conduct further investigation, that's also a violation of the Fourth Amendment, and that really you should be brought to the first available magistrate, and that's what it was before 2008, and so we've been able to make motion arguments that, look, there were magistrates available yesterday morning, it should have been brought, and why wasn't it brought? Unfortunately, those are evidentiary hearings, and so we haven't been able to fully litigate those because we would have to, of course, call the prosecutor to the stand, find out when did they get the police reports, why didn't they, prepare the complaint before 3 o'clock the day before or before 9 in the morning the next day. So, but the point is it's going to require additional litigation, and it's going to require it's going to cause confusion. And when we really need a bright line test, and that's what the Supreme Court said with 48 hours, this is a bright line. If you cross it, you're going to open Pandora's box to litigation, because then the government has the burden of proving that it's not an unreasonable delay and that there's extraordinary circumstances to permit it. And so, we're safe with the 48-hour rule, and until recently, we've never had occasion to claim that they should have been magistrated earlier because we didn't really have a earlier magistrate, the morning ones. I actually favor morning magistrates because it gives our clients an opportunity to get to a judge sooner as opposed to later. And I think it also gives victims a chance to have matters charged sooner as opposed to later. And so, we had the gold standard before 2008. We were charging out hundreds of more cases back then. So there's no reason we can't go back to the gold standard, which would be 24 hours. 48 hours, according to the U.S. Supreme Court, is the actual, the lowest base standard that you cannot go below. It's the floor.
Okay, so the other thing I was looking at is the, just the logistics of it all. So let's say they were, arrested Friday midnight. So, and you're, Attorney General, you're mentioning that the courts don't work on Sunday.
Right,
So then that would mean they would have to be brought
Magistrate
before a
on Saturday.
magistrate on Saturday
correct.
midnight. Because
Right,
if
by that
nobody's
time.
working on Sunday,
Well,
then
that's
it's
correct.
all right, they would have to be released on Sunday.
So that would be the Saturday 3
That's a-
o'clock magistrate.
Oh, okay, so
Right, so
Saturday.
that would be, the situations that we're seeing is that people are getting arrested on a Saturday. For instance, Saturday at 10 o'clock Saturday at 7 o'clock in the morning. DOC isn't fast enough to update us that there's an additional detainee that's just got arrested on Saturday, 7 o'clock. That means that by 7 o'clock on Sunday, that's the first 24 hours, that person has to be magistrated by 7 o'clock on Monday, 7 a.m. Government isn't open at 7 o'clock at the courts. So, and with the court's strict requirement that we would have had to notify them by 4 p.m. on Saturday to get the 9 o'clock or 10 o'clock hearing on Monday. So this is the type of literally hours that we have to deal with. There's no way for us to do it. Because even if we had people come in on Sunday, the court's going to have somebody come in at 6 o'clock or ex parte judge. That's why I was saying ex parte judge. But then they've got to notify the defense attorneys, which requires staff to do that. This isn't like you just call up the judge, ask for an arrest warrant, what the police officers might do on a weekend or a search warrant. They need to have probably a whole staff to notify the defense attorneys, locate them, and so forth.
Yeah, but I think it even goes further back to the Friday, because I'm just looking at the blocks of time, and so
Right. Usually
if you
the
get it
Fri-
on Friday, then, or at least they're arrested on Friday, then, yeah, so the time starts then,
Right.
and so you're running out of time if you don't get it by Saturday.
That is correct.
Yeah,
This
so-
is what we're dealing with. This, I call it helter-skelter. That's from 8 a.m. to 12 p.m. And if you get, and it's always a variable. How many people did the police arrest? And assuming DOC actually captures those arrests and sends it to us. We're scrambling from 3 to 17.
So I guess the option too is to have magistrates work on Sunday.
Right.
So
That's what we're looking at.
Is that something the my judiciary's not here, but,
Yeah.
I mean,
That's
that's
exactly
probably
the
the
question.
next step is
Yes.
ensuring
Yes.
that they're working on Sunday.
Yes, exactly. And I would not, the only problem as a manager is that then we have to start looking at 80-hour weeks, overtime, proper staffing. The defense bar is going to have to make sure that they're available for those hearings on Sunday. You're almost having a 24-hour judiciary, 24-hour criminal justice system. Because the police start this, and it comes from the defendants. They're the ones that create the crimes. People need help out there, and the police are doing their job. But it's now the rest of us that have to catch up to what they're doing.
And I guess I would like to see the statistics too, as, because this idea of, you arrest them and then you have to release them. And so I know you mentioned that particular case if this individual is probably prone to further violence, right? And
That is the
so-
worst case scenario, Senator, is that a violent person does not get a magistrate hearing, is released when they would have been put at Department of Corrections or given an order that is sanctionable and might deter their behavior. But quite frankly, in a situation like that, a person would be in DOC and not going back to finish what they started.
I also understand the other side too as well. It's like if you hold somebody, and they should have been let go too.
And
at the same
Senator, right now, I can assure you that we are not waiting till the end of any 48-hour period to file everything. We file as they're ready, and we send them out. Because if you don't, you're just building up the backlog, and it's going to get worse for logistics.
Okay, thank you. Thank you, Madam Speaker.
Thank you, Senator Paris. Senator Brown?
Thank you, Madam Speaker. I think it's been a long afternoon. I appreciate all the testimony that's been provided. I have no questions or comments. Thank you.
Thank you, Senator Brown. All right, with that, There's no other testimony. We'll ask the sponsor of the bill to close.
Okay, before I close, I just have one more question, general question for the panel. You know, they're talking about a bona fide emergency as justification for extending this window. I just have to ask the question, is the island-wide, well, nationwide lawyer shortage, I'm understanding that we're kind of going through, lawyer shortage, I'm sorry, a lawyer shortage, is the lawyer shortage on Guam bad enough that it would necessitate calling some sort of state of emergency for a lack of legal services to, you know, maybe open up the playbook on what we can or cannot do? Just a general query for anyone that wants to answer.
I believe there is. We've talked about it in different settings with the legislature. The private bar and the government attorneys that serve the people of Guam are insufficient. And as I mentioned, the judiciary has recognized that in the 2023 promulgation order, with the indigent panel no longer being viable. The fact that they increased the temporary licenses for off-island attorneys to practice on Guam from 5 years to now 8 years to allow more attorneys to practice here. My recruiting is bringing in a lot of attorneys off-island, are recruiting at the AG's office. So in my mind as an attorney, when you think that how important legal representation is, and I think that's maybe something that we all at this table can agree to, that your liberty rights for both the defendants and the people of Guam are equally important and are administered by judges who are attorneys and attorneys themselves, officers of the court. So what we do about it is a bigger question, Mr. Chairman. I do have a bill that's just waiting to be drafted to require the University of Guam to give Protect scholarships to, like myself. I was a 1988 Protect scholarship recipient. I was informed at that time that that was one of the last ones that they were giving out. So we've all aged out to this point in our lives versus growing our own attorneys on Guam, which this Protect scholarship program was successful. We were getting lawyers that were getting part of their tuitions paid and coming back to Guam. And I think that we need to do that again. But you plant the seed and you wait for it to be harvested. So there's nothing short right now in terms of fixing the problem, except bringing them from off-island, in my opinion. And it is an emergency situation.
If I may, there's a lot of legal services on Guam that can be done if we follow the Washington model with limited legal practitioners. So they're sort of like paralegal pluses. And if we adopt that model here on Guam, there's still a lot of lawyers on Guam that are practicing. It's just that they're busy doing busy work that could be done with something like a legal license or a limited license professional. A lot of will drafting, orders drafting, stuff like that. They have that model in Washington State. If we try to employ that here on Guam, that could be a solution.
Thank you.
Yeah, I mean, we're always looking at ways of attracting more attorneys to Guam because clearly there's a shortage. Like there was a time before you could sell your practice. We're reaching a point where attorneys are going to have to pay other people to take over their practice. And so that's not a very good situation. So, I mean, we've proposed some recommendations like maybe having government attorneys also take court-appointed cases because for some reason you might be the legal counsel to Triple J, you might get a court-appointed case, but if you're an experienced former prosecutor that works at Rev and Tax, for some reason you can't carry one. So there's like an unfair burden that's being borne by the private sector, and maybe that will help out with the shortage of attorneys as well. And we're always looking to hire, and we're always encouraging people to go to law school. UH Law has an online program that people should take advantage of. But as far as declaring it an emergency that would warrant holding someone longer than 72 hours, I'm pretty sure the U.S. Supreme Court would say that that's not a bona fide emergency.
Likewise, not being able to process police reports and magistrate complaints is not going to be considered a bona fide emergency.
However, if you don't have any lawyers to do it, what are you supposed to do? You know, I mean, it's the difference between the victim's rights and individual liberties. You know, what do you do in the situation where you have to let somebody go and that person kills somebody out there or severely injures them, for that matter?
Thank you, gentlemen, for your perspective on that. The legislature does not have the authority to declare states of emergency, but I'm just kind of spitballing that idea out there as a potential alternative, things we could look at. You know, as a senator, you know, as a governing philosophy, I always try to, you know, and someone mentioned that I could sometimes be a little bit naive, and there's a little bit of truth to that. I always try to take every bill that's offered to me with the grain that it's being offered in goodwill for the good of the people of Guam. And so that's how I'm looking at this bill too. I'm not even sure myself if I necessarily would vote for this bill, but as a lawmaker, this is our mechanism for how we can have this conversation in public. This is how we can, you know, make the case, not just to us senators, but to the public at large, that these changes are necessary or not necessary. And so, you know, my own mind is not made up on this. I did not run on public safety as one of my main platforms, but that being said, as a senator, that is a responsibility of all of us. And so, forwarding bills from the public defender and the Attorney General's office is my way of helping towards the public safety discussion. You know, I've also introduced other legislation like Castle Doctrine bills that, you know, I think are good for the community. And so all of these ideas, I think, should be looked at and discussed by the community, and even if these bills don't fail, even if we introduce them and they're not going to go anywhere, or they're dead on arrival, as some people have said, it's important we have the discussion. And other speakers have said that we are having a real spike in the crime, with the meth especially. It's everywhere. And so we should definitely look at all options on the table. But that being said, we should always respect the rule of law primarily. And between being effective and following the rule of law, we need to find the proper balance to really do right by the people of Guam. So I look forward to future discussion. I look forward to what potential changes you would offer the speaker as she goes through the committee work on this. And I hope to see this bill continue the legislative process, whether it pass or fail, just so we could see some sort of resolution for the problems that we're running into today. And with that, Madam Speaker, I yield the rest of my time. Thank you.
Thank you. Attorney General, I have one more question for you. Is there anything that limits a prosecutor, or after he leaves your office, from, are they privy to confidential information, would you say?
Oh, yes, they are.
Is there something that limits them from
Sharing it?
no, but representing clients against the prosecution?
Yes, Rule 1.9 might do that. The people of Guam, because they're representing the people of Guam, so for them to, on a current basis or on a, when they leave the AG's office, I think there's a, they've got the basic restriction. Any cases that they dealt with at the AG's office, they would be disqualified from. Yeah. So for the most part, but that limits it. Like we all lawyers, that cases that I was court appointed to,
because one of the arguments that I saw in the governor's brief was that the AG's office represents agencies, so they're privy to confidential information, so they should not be they should be limited, I guess, in their prosecution because they were privy to that confidential information. Yet, if you leave the AG's office, there seem to be no barriers to entering as amicus against the Attorney General or defending, I guess, separate cases. That's not a problem. But, and then we have attorneys on Guam, you know, representing multiple parties. So they go from the AG's office to the governor's office to the court.
Yes.
And then we have these other parties in the court. Yeah. I'm just, the Guam Bar has announced that there is a shortage of lawyers on Guam. I think that was what they said at the last meeting, and they are looking to other means for appointing lawyers to indigent defense work. However, and they are also aware that the ProTech scholarships that it takes them to go and lobby. That's at the University of Guam now, who sets a priority for the ProTech scholarships. So it's a matter of proving that to the people making that decision at the University of Guam, that is more of a priority or more of a need. I think it's supposed to be needs-based on Guam versus what their current priorities are, which I know cover doctors and other things. But yeah, but I've been suggesting to them for quite some time now that that's exactly what they need to do, is change the priorities of, or at least include it as one of the priorities at the ProTech scholarships.
Or the legislature to pass a statute requiring it, you know, that because it's government taxpayer funded.
But then we get in, well, that's a possibility, of course.
That was what I was thinking, because I understand they still do, they can give legal scholarships up there from what I was told.
No, they can. I'm saying it is within their ability to do so. It's a matter of the bar proving the need versus, you know, apparently the medical doctors have proven the need for additional doctors on Guam. So that's, you know, there's only a certain limited pot, and we just need to prove the need that's more of a priority than something else that they are currently covering, like
Yes, Madam Speaker.
social workers, nurses, doctors. All right. There being
But
no further
we would definitely support AG Moylan's bill to create a ProTech scholarship for law students.
There is a ProTech scholarship, and it would cover lawyers.
Madam Speaker, I don't just want to jump in without being invited, but I can tell you that the GBA is having these conversations. We're absolutely committed to getting back on that list. We're hoping that's going to happen soon. But I know I've heard your comments, and these discussions are already underway.
Yes, I talked to the bar president about that. All right. For those who've not testified, the committee will continue to accept written testimony on Bill 259 and Bill 235 for the next 5 working days until April 26, 2024. Testimony can be emailed to Senator Terlaje@gmail.com or hand-delivered here to the Guam Congress Building for my office. And this public hearing is now adjourned, and it is 5:40. Situs Masi.